lecturers and the researchers, presenters, students who've joined in for the third day of the international webinar organized by Sri MD Shah Mahila College in academic collaboration with Chanakya National Law University. I welcome you all to this deliberation. Today, our chairperson for the technical session is Dr. Shalini Dikshit. Dr. Dikshit is Assistant Regional Director, Indira Gandhi National Open University, Patna. Life member of Indian History Congress Association for the Study of History and Archaeology, Indian Society of Gandhian Studies, Indian Society of Indic Studies, Indian Science Congress Association. She is a member of the editorial board of BIOS International Journal, International Research Journal of Social Sciences and Humanities Studies. She has participated in innumerable national and international conferences, seminars. She has various publications to her credit. Patriarchy and Feminine Space, a study of women in early Buddhism. She's awards are Junior Research Fellowship and Postdoctoral Fellowship for minimum from Ministry of HRD, Government of India. She's also been awarded the Shiksha Ratna Puraskar 2013, Educational Excellence Award 2014, Mother Teresa Excellence Award 2014. It's such a pleasure to see you, ma'am, and we welcome you to this deliberation. If the chair permits, could we kindly start with the technical session? Madam Dikshit, could we please
start? Sure. Thank you so much, Vidya Lakshmi ma'am. A very good morning to all the dignitaries present here. It's indeed a great pleasure that I have been given this opportunity to chair the session, especially MD Shah Mahila College, that is affiliated under SNDT Mumbai University and Chanakya National Law University, Patna. And I extend my gratitude to Professor Ranjana Mishra, who gave me this opportunity. So thank you so much. Yes, ma'am, definitely we can start. Welcome. Over to you, Vidya Lakshmi. Should I be calling or you will be
I will call for the papers.
Thank you so much.
Thank you so much. The first speaker for the day is Miss Ishika Busa, Symbiosis Law School, Hyderabad. The title of her paper is Violation of Human Rights in Sudan and North Korea, a study during pandemic times. Miss Ishika Busa.
It's Ishika Busi, ma'am.
Busi? Okay. Yes. My apologies.
It's all right. Also, ma'am, could I present the PPT?
Yes, you could. You could share your screen, dear.
Okay. Is it visible?
It says join the conversation, some blog and Zoom. I don't see a PowerPoint here.
It's not seeing.
Okay. Yes, ma'am, you can switch the PPT. It's showing your web browser.
Yeah, we can see your web browser. You can just switch on your PPT and then share the screen.
Now?
It's opening. Wait.
It's opening. Yeah, it's done.
Visible, right?
Yes, please do.
Okay, so I can start?
Yes, you could.
Okay, so good morning to everyone present here. I'm Ishika Busi, first year student from Symbiosis Law School, Hyderabad. And I'll be presenting my paper, which is the title of which is Violation of Human Rights in Sudan and North Korea, a study during the pandemic. To begin with, I would like to explain what is human rights. Okay, so human rights are granted to a human being by the virtue of being a human, and it is applicable to every person regardless of their gender, caste, creed, sex, race, religion, etc. So it is granted without any kind of discrimination. And the legal document which recognizes the human rights is the Universal Declaration of Human Rights, which together 192 countries have come together to ratify the same and are under an obligation to respect and be bound by it. Coming to violation of human rights, it takes place in different fields, cultural, civil, social, economical, etc., and in various means as well. For example, human trafficking, there is rape, genocide, war crime. There are different ways in which human rights can be violated. It could be either an organization violating somebody's human right or an individual violating someone else's human right. So it can take place in various means. And the main issue that the human rights violation is the basic integrity of the human being is violated, wherein a person's personal space is violated, does not have any control over what they are doing, what they might do, or any control over it whatsoever. Coming down to the main countries of my paper, which is violation of human rights in Sudan. I have chosen these two countries because the human rights at present have been entirely being violated and are still continue to be violated over there. So violation of human rights in Sudan. In Sudan, there is a region known as Darfur, which is one of the largest regions in Sudan. It is up to 250,000 square kilometers, which is known to be as the size of France. And it comprises of almost 6 million people living in this area. And there are different tribes which come together in this particular area, namely the Far, Mazlit, and the Zagwa tribe. Now, what happened is that these tribes are not exactly in consensus with what the Sudanese government is doing, and they are completely unhappy, which is what resulted in the present day crisis as on date in Sudan. So, because of them not being happy with the Sudanese government supporting the Arabs and not the non-Arabs, the tribes are very unhappy with that. And so separate parties were formed, which is the SLA, which is the Sudanese Liberation Army, which is nothing but the tribes which have come together, which is the Far and Mazlit, and they are known as the dominant tribes of the area as well. Coming to the GEM, which is nothing but the Justice Equality Movement, which is again the Zagwa tribe. In a way, it is which is mainly the Zagwa tribe, which is against these two Far and Mazlit tribes. So now there is a civil war going on between these two tribes. Now, and they have questioned the government, the Sudanese government. And since the Sudanese government did not want to want any kind of questions on their authority, they have funded and sponsored a militia group, which is known as the Janjaweed. The Janjaweed are basically the government-sponsored militia, which in turn are in response to these two groups, which is the SLA and GEM. And so the Janjaweed, basically, which is the militia group by the government, as mentioned before, they have been violating human rights in various ways. People are being displaced from their houses, and especially the people from the different tribes like the Far, Mazlit, and Zagwa are being targeted and captured every now and then because they are the ones who organize the other groups. So the Janjaweed is capturing them, and the girls are being charged with zina. Zina meaning a sexual intercourse between two people without any kind of lawful marriage. And so the Janjaweed are raping girls, young girls around the age of 12 to 13 and violating them. And then they are again punished for the same crime which they did not even intend on being. Now, coming to this, the United Nations raised an alarm regarding the same in 2004. And then after United Nations raised an alarm, then in 2007, something called United Nations Hybrid Operation Plan was launched in the year 2007, which is the UNMAID, which helped the people reduce the violence in the particular area. And after reducing the violence to a certain extent, it has not completely eradicated. It still exists. But to a certain extent, the violence has been stopped. And not only that, with coming of COVID and the pandemic, the socioeconomic conditions in the area have only worsened because there are no proper supplies, there are no proper education to people being given regarding how to take care or what to do, what not to do. And the civil war and the communal violence is still ongoing. So COVID has only made it worse. And the fact that the Sudanese government has not really allowed the Human Rights Watch and the Human Rights Commission to get into the country to help people out. They have just denied any kind of access to them, and more so ever, they deny any kind of charges against them. They say that the Sudanese government is not sponsoring the militia, which is the Janjaweed, and they completely deny any kind of charges. Though they have said, they have even declared the Janjaweed as a criminal, but they deny to accept any kind of charges that the government might have against it. Now, coming to another country, which is the other part of my paper, is violation of human rights in North Korea. In North Korea, the Democratic People's Republic in Korea is the party which is currently ruling over there. And it has denied people any kind of contact with the outside country. In a way, the government controls everything that you do over there. You are not allowed to move from one particular area. You are supposed to have some kind of a regulated hairstyle. The government has approved up to around 20 hairstyles, 9 for women and 8 for men, 28 hairstyles. And only those are the certain hairstyles which the citizens of the country are allowed to have. In a way, the government is very controlling. So if the government finds you disloyal to the regime in any particular way, or if they think that you are a threat to the government, or you might have questions, or you might oppose them in certain way, you are sent to prison camps. In prison camps, they use the means of torture, fear of punishment, as one way to control people, where they torture you by starving you, by beating you, by making you do excess human labor and things like that. So that is the way they torture their own people, and people are scared to speak up because if they do, they are sent. And not only that, the children are punished for the crimes of the parents. So for example, if the parents had done something, then the children will be punished for it. Sometimes families together are taken away, and nobody can question the government because it's the government's doing. So the prison camps are really known to be horrible, and they are located at the end of every city. If you look at it, and they have denied, and though they are a part of the international conventions like the Geneva Convention, the ICCPR, which is the International Covenant on Civil and Political Rights, and the other 4 Geneva conventions, they still do not go by it, and they violate it. And along with violating the Geneva Conventions, they also do not allow any kind of access to the Human Rights Commission and the Human Rights Watch to the country. And so there is no access that anybody has. So it is difficult to get any kind of information on the country as such. So all we know, for example, I would like to tell you a case about Ottoman Vampire. He was a college student who had gone for a tour just with his friends. And there he stole a poster for fun, and he was sent to prison camp for it. And next thing you know, things escalated. And by the time he reached his own country, he was in a vegetative state and died in a couple of months, which tells us that we don't exactly know what went down in the prison camp with him, because he was sentenced to prison camp. But again, the North Korea denies any kind of charges. And during the pandemic, the restrictions have only worsened. For example, the people are not allowed to move from one certain area to another. So they end up living there, and they end up even settling up there because the moment is not as free. So during the pandemic, for example, if somebody is coming from China or coming from another country, they cannot quarantine in their own houses. They're supposed to quarantine in the government facilities where the medicine, the supplies, and the food is not quite proper, because of which the people are suffering. So even though they might not have COVID, they might certainly have something else because of the poor facilities in the government. And they have passed orders like shoot and sight orders if they are found anywhere near the border. And the pandemic has only worsened the restrictions. With this, I would like to end my paper, and my paper ends with talking about how the Human Rights Commission and the Watch can take steps to further help the crisis going on, because as on date, those steps are being taken, they are at a slow pace, and the pace needs to be increased faster because human rights currently are being violated as we speak. Thank you.
Thank you so much, Ishika. We proceed to the next presenter, Ms. Kalyani Kumari, Research Scholar, Department of IRPM, Tilkamanji, Bhagalpur University, Bhagalpur, Bihar. Ms. Kalyani, are you with us?
Yes, ma'am.
Yes. Ma'am, would you like to share your screen, your PowerPoint? Or are you going to read out the paper?
Excuse me, ma'am. Please check if Dr. Shalini Dixit is there, or there is some.
Yeah, Dr. Shalini Dixit is okay. Yeah, I can see her.
I'm very much here.
Yes, there could be a little technical thing, but Madam is there. I can see her on the screen.
Yes, I'm here. I'm here.
Yes. Can we proceed, ma'am? Shalini, ma'am, can we proceed, please?
Yes.
Yes. Yeah. Ms.
Sure,
Kalyani,
definitely,
please
definitely,
proceed.
ma'am. In the last year,
Yes, Dr. Dixit is with us. Kalyani Kumari, please kindly proceed with your presentation.
Okay. Thank you, ma'am. Thank you, all of you. I'm audible, ma'am.
Yes, you're audible.
Okay, thank you. My paper topic is भारत में विवाह निबंधन वैवाहिक मानव अधिकार का एक प्रतिबिंब। भारतीय समाज में विवाह निबंधन एक अति आवश्यक कदम है। मैं ये बता रही हूँ विवाह निबंधन के बारे में, जो कि विवाह करने के बाद लोग विवाह निबंधन नहीं करवाते, तो उस पे मेरा एक रिसर्च का ये टॉपिक है। ओके, भारतीय समाज में विवाह निबंधन एक अति आवश्यक कदम है। समाज में बढ़ती समस्याओं, कुप्रथाओं जैसे बाल विवाह, अवैध विवाह, विवाह में धोखाधड़ी इत्यादि संगीन मामलों पर विचार करते हुए उच्चतम न्यायालय ने 14 फरवरी 2006 को सभी राज्यों में विवाह के निबंधन को अनिवार्य घोषित कर दिया है, ताकि भविष्य में आने वाली चुनौतियों का सामना करने में सुविधा प्राप्त हो सके। समाज में बढ़ती परित्याग की स्थिति, तलाक इत्यादि में वृद्धि के फलस्वरूप विवाह का निबंधन और भी आवश्यक प्रतीत होता जा रहा है। जिस प्रकार समाज में विवाह का होना महत्वपूर्ण माना गया है, ठीक उसी प्रकार इसे अटूट बंधन में बांधने के लिए तथा भविष्य में विवाह की सुरक्षा कायम रखने के लिए एवं आगामी चुनौती से बचने के लिए विवाह निबंधन एक आवश्यक कदम होगा, जिसके लिए समाज को जागरूक होना होगा और उसके लिए सजग भी होना पड़ेगा। विवाह निबंधन को अनिवार्य बनाने के मुख्य उद्देश्य महिलाओं को सुरक्षा प्रदान करना है। मैम इसके कुछ ऑब्जेक्टिव मैं बताती हूँ। इसमें कुछ ऑब्जेक्टिव्स हैं मैम, जिसमें महिलाओं को सुरक्षा प्रदान करना, जिसमें कि शादी के बाद महिलाओं को कई प्रकार की समस्याओं का सामना करना पड़ता है, जैसे घरेलू हिंसा, पति की मृत्यु हो जाने पर उसे घर से निकाल दिया जाता है, उसको उसका वो अधिकार नहीं प्राप्त होता है। बाल विवाह को रोकना, इससे समाज में होने वाली बाल विवाह से बच्चों को बचाया जा सकता है, जिसमें उनके न्यूनतम आयु 18 साल होती है, उसको निर्धारित किया जा सकता है। अवैध विवाह, द्वि विवाह, बहु विवाह को रोकना, ताकि पति या पत्नी के जीवित रहते दोबारा विवाह न किया जा सके। अवैध संबंध के कारण पहली पत्नी को उसका अधिकार न छीना जाए, बहु विवाह की रोकथाम हो सके, महिलाओं को उसका अधिकार एवं भरण पोषण प्राप्त हो सके तथा वैध बच्चों को उनका हक प्राप्त हो सके। हम इसका कुछ मैं बैकग्राउंड बता रही हूँ, जिसमें कि पहले कौन सा एक्ट लगता था जिसमें कि हमारा मैरिज रजिस्ट्रेशन होता था, लेकिन अभी कुछ 2 एक्ट में ही हो पा रहा है, जो हिंदू विवाह अधिनियम 1955 के तहत हो रहा है और विशेष विवाह अधिनियम 1954 के तहत हो रहा है। लेकिन इसके पहले क्या होता था? विवाह निबंधन की अनिवार्यता के लिए इसके पृष्ठभूमि को जानना आवश्यक है। आजादी के बाद लैंगिक असमानता के मुद्दे हल करने के लिए भारत सरकार के द्वारा कई पहल की गई थी, किंतु अब तक इसमें कोई सुधार भी नहीं हुए। हालांकि प्राचीन प्रथाओं में इसको प्रतिबंधित कर दिया गया था, जिसमें बाल विवाह वगैरह आते हैं, और बहुत सारा ऐसा कस्टम था जो हम लोग अभी भी चला रहे हैं। और इसके लिए प्राचीन प्रथाओं को प्रतिबंधित और दंडित करने वाले कानूनों के बनने के बावजूद हमारे समाज में बाल विवाह, द्वि विवाह और लिंग हिंसा अब तक जारी पाई गई है। अदालतों में वैवाहिक स्थिति के संबंध के कई मामले लंबित पाए गए हैं। वैध विवाह साबित करने वाले रिकॉर्ड प्रमाण की अनुपस्थिति के कारण महिलाओं को अक्सर पत्नी की स्थिति से वंचित कर दिया जाता है, जिसके लिए अदालतों ने बार बार विवाह के निबंधन को अनिवार्य बनाने पर जोर दिया, ताकि महिलाओं और विवाह से पैदा हुए बच्चों को उनके अधिकारों से वंचित न किया जा सके। आए दिनों शादी में धोखाधड़ी मामले दिखाई देते हैं। अनिवार्य पंजीकरण के अभाव में वैध विवाह की शर्तों को पूरा किए बिना महिलाओं को धोखा दिया जाता है। यह महिलाओं को सामाजिक मान्यता और कानूनी सुरक्षा से वंचित करता है। इस तरह के कपटपूर्ण विवाह विशेष रूप से अनिवासी भारतीयों में बढ़ रहे हैं। जन्म, मृत्यु और विवाह पंजीकरण अधिनियम 1886 में केवल कुछ वर्गों के लोगों के लिए ही जन्म और मृत्यु का, वो भी स्वेच्छा से, पंजीकरण के लिए प्रदान किया गया था, जबकि क्रिश्चियन मैरिज एक्ट और पारसी मैरिज एक्ट में ये मैंडेटरी है, इसको करना ही है। विवाह के पंजीकरण का प्रावधान भारत के विभिन्न कानूनों के तहत मौजूद पाए गए हैं, जैसे हिंदू विवाह अधिनियम 1955 और विशेष विवाह अधिनियम 1955 में ऑलरेडी बोल चुकी हूँ, और पारसी विवाह अधिनियम और ईसाई विवाह निबंधन की अनिवार्यता बिल के पास होने से ऐसा कोई अधिनियम नहीं बना था जो केवल सभी विवाहों का रिकॉर्ड रखने का प्रावधान करता हो, जिसमें धर्म, जाति, क्षेत्र, प्रथा या रीति रिवाजों की परवाह किए बिना देश के किसी भी व्यक्ति के लिए यह उपलब्ध किया जा सके। इसलिए 2006 में सीमा बनाम अश्विनी कुमार के मामले में सर्वोच्च न्यायालय के द्वारा निर्णय दिया गया कि सभी व्यक्तियों के विवाह को जो विभिन्न धर्मों से संबंधित भारत के नागरिक होंगे, उनका विवाह अनिवार्य रूप से उनके संबंधित राज्यों में पंजीकृत होना ही चाहिए जहां विवाह किया गया है। विवाह के अनिवार्य पंजीकरण को इनके दायरे में शामिल करने के लिए जन्म और मृत्यु पंजीकरण अधिनियम 1969 में संशोधन करने का प्रस्ताव होगा। विवाह में किसी भी जाति या धर्म या जनजाति के जोड़े के बीच किसी भी कानून या प्रथा के तहत किसी भी रूप तरीके से मान्यता प्राप्त विवाह या पुनर्विवाह सहित किसी भी कानून के तहत पंजीकृत विवाह शामिल होगा। विवाह का पंजीकरण वास्तव में पहले से मौजूद कानूनों को और बेहतर बनाना है, जिसका उद्देश्य बाल विवाह को रोकना है, द्वैत विवाह, बहु विवाह, अवैध विवाह, इन सबको रोकना है। यह जल्दी और जबरन विवाह जैसी प्रथाओं को समाप्त करने में भी सहायता करेगा। यह लैंगिक और समानता प्राप्त करने और महिलाओं को सशक्त बनाने के लिए सहायक होगा। इसमें पात्रता इससे विवाह निबंधन की पात्रता होती है, पुरुष की आयु 21 ईयर्स होनी चाहिए और महिलाओं की आयु 18 ईयर्स होनी चाहिए। आवेदक जो होते हैं उनके पति या पत्नी, वो कोई दोनों में से कोई भी एक भारत का निवासी होना जरूरी है। और विवाह का जो पंजीकरण होता है वो शादी के 1 महीने के अंदर करवा लेना चाहिए, ना 30 दिन के अंदर होना चाहिए। यदि वर या वधु में से किसी का भी तलाक हुआ हो पहले से, तो उसको उस तलाक का डिक्री या फिर उसका जो प्रमाण पत्र मिला है वो उसको जमा करना होता है। विवाह निबंधन की कुछ आवश्यकताएं मैं बताना चाहती हूँ। विवाहित जोड़ों के लिए विवाह निबंधन का प्रमाण पत्र एक सबसे महत्वपूर्ण प्रमाण होता है, जिसको इन फ्यूचर में कभी भी कोई भी प्रॉब्लम आने पर वो दिखा के उससे जो भी समस्याएं आती है फ्यूचर में, उससे वो बचा जा सकता है कि वो उसकी वाइफ है या वो उसका हस्बैंड है या नहीं। इसके लिए कुछ चीजें हैं। विवाह निबंधन प्रमाण पत्र पति पत्नी के संबंध को प्रमाणित करता है। पति या पत्नी का पासपोर्ट बनाने में यह प्रमाण पत्र सहायक होता है। विवाह के उपरांत युगल विदेश जाना चाहते हैं या वहां घूमने की सोच रहे हैं और उन्हें सरकारी संस्थान में विवाह प्रमाण पत्र के आधार पर भी वीजा दिया जा सकता है। यदि पति किसी दूसरे देश का नागरिक हो और वो अपनी पत्नी को वहां ले जाना चाहता है, तो उसके लिए नागरिकता के लिए उसको भी वहां पे उसका मैरिज का सर्टिफिकेट दिखाना बहुत जरूरी होता है। यदि विवाह के बाद पत्नी का नाम बदलना हो तो उसको सारे डॉक्यूमेंट में नाम चेंज करने के लिए इसका प्रमाण पत्र बहुत जरूरी है। अवैध विवाह को रोक लगाने के लिए इस प्रमाण पत्र की सबसे ज्यादा जरूरत होती है। बाल विवाह की बढ़ती समस्या पर लगाम लगाना है। इस प्रमाण पत्र की आवश्यकता महिलाओं को अधिक होती है क्योंकि शादी में धोखाधड़ी होता है, तालाक का मामला आता है, तो जिससे विवाह का प्रमाण पत्र होने से स्त्री का जो भी अधिकार होता है वो उसको अधिकार मिलता है। अपना गोत्र चेंज करने के लिए भी लोग इसका सर्टिफिकेट लेते हैं। आजकल बच्चों को स्कूल में जरूरत पड़ता है इसका, स्कूल जाते हैं तो वहां पे भी मांगा जाता है कि पेरेंट्स हैं ये है, तो उसका अपना खुद का सर्टिफिकेट देना जरूरी है। विवाह के प्रमाण पत्र के द्वारा सरकारी सुविधाओं का लाभ मिलता है, जैसे राशन कार्ड बनाने के लिए, LIC क्लेम करने के लिए, और विवाह संबंधी जो भी कानूनन जरूरत होती है उसको उसके लिए उसका सर्टिफिकेट चाहिए होता है। जॉइंट अकाउंट खुलवाने के लिए होता है। और सबसे जरूरी है कि विवाह से संबंधित जो भी मुकदमे होते हैं उसके साक्ष्य के लिए ये सबसे ज्यादा जरूरी सर्टिफिकेट है। विवाह निबंधन कार्यालय से प्राप्त प्रमाण पत्र की आवश्यकता का मामला जो होता है वो तलाक में सबसे ज्यादा जरूरी होता है, और ये इसलिए होता है क्योंकि ये जो दोनों जोड़े होते हैं उसके सुरक्षित भविष्य के लिए ये सबसे ज्यादा जरूरी है। इसमें अभी हमारे भारत में 2 कानून चल रहा है जिसमें विवाह का निबंधन कराया जाता है, जिसमें है पहला हिंदू विवाह अधिनियम 1955। हिंदू विवाह अधिनियम उन मामलों में लागू होता है जहाँ पति और पत्नी दोनों हिंदू, बुद्ध, बौद्ध, जैन या सिख होता है, या जहाँ वे इनमें से किसी भी धर्म में चेंज हो चुके हो लेकिन वो हिंदू ही कहलाते हैं। इस प्रक्रिया में पहला कदम उन सब रजिस्ट्रार पर लागू होता है जिनके अधिकार क्षेत्र में विवाह को रद्द कर दिया गया हो या विवाह के लिए किसी भी पक्षकार के द्वारा निवास किया गया हो। इस अधिनियम के अंतर्गत विवाह निबंधन के लिए अपने स्थानीय निबंधन कार्यालय में दोनों पक्षकार को एक आवेदन पत्र भरना होता है, उस पर हस्ताक्षर करना होता है और शादी के समारोह की कुछ तस्वीरें, ये हिंदू विवाह के बारे में मैं बता रही हूँ, तो उनको अपना शादी का एक तस्वीर देना। मैम ये होता है क्या है कि हिंदू विवाह में हमारा जो होता है ना वो पहले से रीति रिवाज करना बहुत जरूरी होता है कि हमारा जो शादी होता है वो वहाँ पे कोर्ट मैरिज जल्दी नहीं होता। कोर्ट मैरिज सिर्फ लव मैरिज के केस में होता है, लेकिन अगर नॉर्मली हम अगर जाते हैं रजिस्ट्रेशन कराने के लिए तो उसमें हमें हमारे रीति रिवाज के तहत जो भी हमारी शादी हुई वो उसको दिखाना पड़ता है। ठीक है, तो उसमें अपना एक निमंत्रण कार्ड उनको देना है, आयु प्रमाण पत्र हो गया, फिर उनका एड्रेस प्रूफ, निवास प्रमाण पत्र, ये सब करके और एक एफिडेविट बना के कि आप लोग दोनों सक्षम हो शादी के लिए या प्रमाण पत्र बनवाने के लिए, तो वो उसको एक एफिडेविट वहाँ पे जमा करना पड़ता है और ये सब रजिस्ट्री ऑफिस में होगा। हिंदू विवाह अधिनियम के सेक्शन 5 में पक्षकार के बीच विवाह को कानूनी और वैध मानने के लिए कुछ शर्तों को पूरा करना होगा। अधिनियम की धारा 7 में हिंदू प्रथा या रीति के अनुसार विवाह के ही अनुष्ठापन का विवाह रजिस्टर्ड किया जा सकता है। हिंदू विवाह अधिनियम 1955 की धारा 5 के आधार पर विवाह को केवल तभी वैध माना जाएगा जब विवाह के दोनों पक्षकार हिंदू होंगे। यदि विवाह में कोई भी पक्ष मुस्लिम या ईसाई होगा तो ये विवाह वैध नहीं होगा, इसको रद्द कर दिया जाएगा। वो हम आते हैं फिर जो स्पेशल मैरिज एक्ट के तहत होता है वो उसमें वो कर सकते हैं। मैं स्पेशल मैरिज एक्ट के बारे में कुछ बताना चाह रही हूँ। स्पेशल मैरिज एक्ट 1955 भारत के सभी नागरिकों पर लागू होगा। कोई भी व्यक्ति चाहे वह किसी भी धर्म या जाति का होगा, विशेष विवाह अधिनियम 1955 के तहत विवाह को रद्द भी किया जा सकता है यदि वो जो सारा प्रोटोकॉल फुलफिल नहीं करते हैं। तो इस अधिनियम के तहत अपनी शादी को रजिस्टर करने का इच्छुक व्यक्ति को संबंधित विवाही अधिकारी को निर्दिष्ट रूपों से लिखित रूप में पहले सूचना देना होता है कि उन्हें शादी करनी है या रजिस्टर करवाना है। उसके लिए उस तारीख पे जाकर उस अधिकार क्षेत्र में कम से कम 30 दिनों की अवधि के लिए उन्होंने निवास किया होगा, तभी वो ये काम कर सकते, क्योंकि वो जहाँ जिस क्षेत्र में वो रह रहे हैं उसी क्षेत्र में वो करवा सकते हैं। विशेष विवाह अधिनियम विवाह के पंजीकरण और अनुष्ठापन दोनों से संबंधित होता है। इस अधिनियम के लिए कुछ शर्तें होती हैं जो सेक्शन 4 में दिया हुआ है। विवाह के समय दोनों पक्षों में से किसी एक का जीवन साथी नहीं होना चाहिए। जो पहले मान लो कोई पहले ऑलरेडी मैरिड है तो उसका हस्बैंड या वाइफ नहीं होना चाहिए। विवाह के समय दोनों पक्षों में से फैसला लेने की क्षमता होनी चाहिए। दोनों पक्षों ने विवाह के समय वर की आयु 21 वर्ष और वधु की आयु 18 साल होनी चाहिए। दोनों पक्ष निषिद्ध संबंध या फिर वैसे संबंध जो हमारा जैसे चाचा भतीजी नहीं हो सकते या मामा भांजी नहीं हो सकती, इस तरह के कुछ सेक्शन दिए हुए हैं इसमें, वो उसके अकॉर्डिंग नहीं होने चाहिए और निश्चित संबंध में नहीं आने चाहिए। लेकिन एक पक्ष को अगर मान लो हमारी कोई प्रथा है कि नहीं हमारी प्रथा के अनुसार मेरा ये भाई से ही शादी हो सकता है या फिर जैसे मुस्लिम में होता है ये सब बहुत सा, तो वो कर सकते हैं। उसके लिए उसमें कुछ भी कोई नहीं एक्ट किया हुआ, वो प्रथा के अकॉर्डिंग कर सकते हैं अगर वो मानते हैं वहाँ। तो इसकी कुछ विशेषताएं मैं बताना चाहती हूँ। विवाह निबंधन विवाह का कानूनी प्रमाण पत्र प्राप्त करने के लिए करवाया जाता है। भारत के सभी धर्मों के लिए विवाह का निबंधन करवाना सभी विवाहित जोड़ों के लिए अनिवार्य कर दिया गया है। विवाह प्रमाण पत्र के माध्यम से महिलाओं के अधिकारों की रक्षा की जा सकेगी। इस प्रमाण पत्र के माध्यम से कई अन्य दस्तावेज भी बनवाए जा सकते हैं। विवाह प्रमाण पत्र बनवाना अभी और आसान हो गया क्योंकि अब ये ऑनलाइन हो चुका है। सारे मैक्सिमम स्टेट में इसको ऑनलाइन कर दिया गया। जैसे इसका एक जो हमारे पूरे भारत के लिए है वो है ऑनलाइन मैरिज रजिस्ट्रेशन.in पे भी जाके वो कर सकते हैं। और अभी स्टेट वाइज भी हो गया। पीएम मोदी योजना 2021 के तहत इसको सब स्टेट में अब कर दिया गया है आधिकारिक रूप से कि इसमें आप ऑनलाइन कर सकते हैं। विवाह निबंधन ऑफलाइन के माध्यम से होता है। विवाह निबंधन करवाने के लिए एक निर्धारित शुल्क का भुगतान करना होता है। जो भी शुल्क लगता है जैसे हर मंथ अगर बढ़ता जाता है तो वो अकॉर्डिंग टू स्टेट कि आपको उसमें 50 रुपीज ले रहे हैं या 100 रुपीज ले रहे हैं। यदि पति की मृत्यु हो जाती है तो पत्नी को विवाह के प्रमाण पत्र के माध्यम से उसके जो अधिकार होते हैं वो प्राप्त होते हैं। नागरिकता प्राप्त करने के लिए इस प्रमाण पत्र का उपयोग किया जाता है अदर कंट्री में। विवाह निबंधन के माध्यम से बाल विवाह पर रोक लगाया जाता है क्योंकि वो सबसे बड़ा मुद्दा है अभी हमारा बाल विवाह। इसके लिए कुछ मैं कंक्लूड करती हूँ इसको। विवाह प्रमाण पत्र अनिवार्य रूप से विवाह के पंजीकरण का कानूनी प्रमाण होता है और विवाह निबंधन का जो प्रमाण पत्र एक आधिकारिक बयान है जो दंपति के वैवाहिक स्थिति को स्थापित करता है। यह एक महत्वपूर्ण दस्तावेज है जिस पर कोई भी यह साबित करने के लिए भरोसा कर सकता है कि वे कानूनी तौर पर किसी से विवाह कर चुके हैं। वर्तमान समय में विवाह निबंधन आधुनिक जीवन शैली का एक अत्यंत ही आवश्यक कदम साबित होगा जिसे विवाहित युगल को अपनाना ही चाहिए। हमारे देश में कई धर्म है और विवाह करने का सबका अपना अलग अलग रीति रिवाज और कस्टम है जिसे सदियों से हम परंपरा के रूप में पीढ़ी दर पीढ़ी निभाते आ रहे हैं। लेकिन हमारा जो कानून है वो इस कस्टम और रीति रिवाज को नहीं मानता, वो पेपर वर्क पे काम करता है, वो सबूत मांगता है कि आप मैरिड हो या नहीं हो। इसलिए हमारा कानून ऐसे विवाह को पूर्णतः विवाह निबंधन के प्रमाण पत्र के द्वारा ही स्वीकारता है। विवाह निबंधन के प्रमाण से समाज में बढ़ती कुप्रथाओं को समाप्त किया जा सकता है। ये प्रमाण बताते हैं कि कुछ
हाँ, संक्षेप में आप बस उसका थोड़ा
ओके। यह महिलाओं बच्चों को सशक्तिकरण के लिए आगे बढ़ाता है, उन्हें सेकेंडरी स्कूल में जाने में सहायता देता है, कौशल का विकास करता है जिससे वे अपनी आर्थिक योग्यता को साकार कर सके तथा स्वस्थ उत्पादक और सशक्त व्यक्ति में परिवर्तित हो सके। वहीं भारत जैसे विभिन्न सांस्कृतिक वाले देश में विवाह संस्था के द्वारा लाखों शादियां कराई जा रही हैं, पर निबंधन के अभाव में विवाह का भविष्य सुरक्षित रख पाना मुश्किल सा प्रतीत हो रहा है, क्योंकि निबंधन बहुत कम हो पा रहा है अभी इंडिया में, जितना भी अभी सर्वे में देखिए वो भी बहुत कम हो रहा है। अतः विवाह निबंधन समय पर ना होने से कई परेशानियों का सामना करना पड़ सकता है। जनसंख्या की गुणवत्ता में मौलिक परिवर्तन लाने के लिए तथा समाज की कुप्रथाओं का अंत करने के लिए, कुरीतियों का नाश करने के लिए, समाज में बढ़ती हिंसा को रोकने के लिए, नागरिकों को एक साथ मिलकर विवाह जैसे पवित्र बंधन को आजीवन बरकरार रखने के लिए अपनी सोच में बदलाव लाना होगा, उन्हें जागरूक होना होगा। और यह बदलाव तभी आ सकेगा जब हम सजग हो जाएं इसके प्रति। यह जागरूकता शिक्षा के प्रसार, विचार विमर्श, व्यवहार कुशल, कार्य कुशलता, कानून की उचित उपयोगिता, माता पिता का सहयोग, समाज का सहयोग को और रीति रिवाज में परिवर्तन लाकर ये सब करके हम परिवार और समाज को आगे बढ़कर आना होगा, क्योंकि विवाह का महत्व परिवार और समाज में समाज से बढ़कर कोई नहीं जान सकता। इसलिए समाज को जागरूक होकर विवाह के निबंधन के वैवाहिक अधिकार के प्रावधान को स्वीकार करना होगा। यह अधिकार नागरिकों की सुरक्षा को ध्यान में रखकर ही बनाया गया है। थैंक यू टू ऑल। थैंक यू।
Thank you, Ms. Kalyani. I'd request the other paper presenters, please kindly adhere to the time limit. It would be very rude on our part if we had to stop your presentation in between. Yeah, please kindly adhere to the timing. Once again, before we go ahead with the next presenter, I would like to welcome Dr. Mohanbhai Patel. Dr. Mohanbhai Patel is the president of our parent body, Jan Seva Samiti, a learned scholar and an history enthusiast, and we are very blessed to have you, sir.
Thank you very much.
Sir,
Thank
if you
you.
permit, can we please
Thank
move
you.
ahead with the next paper?
Thank you.
Yes, sir.
Thank you. Please continue.
Thank you,
Please
sir.
continue. I'm enjoying it.
Thank you, sir. The next presenter for the session is Miss Arshita Anand, student, first year, Chanakya National Law University. The title of her paper are Reproductive Rights of Women in India. Miss Anand, are you with us? Yeah, please kindly start your presentation. Miss Arshita Anand. Madam, Arshita. Miss Arshita. If the chair permits, do we proceed to the next paper, please, ma'am?
Yes, sure, definitely, ma'am.
Arshita, you aren't audible. She just put a text to me. Arshita, we continue with you later. We go ahead with the next one. Mr. Saurav Kataria, are you with us? Mr. Saurav? We go to
No,
the
ma'am,
next
he
one.
is not well. He has some medical emergency,
Okay.
so he is not coming.
Okay. Thank you, Mr. Saurav, for informing us. We go to Miss Safina V. She's a research scholar from University of Calicut. Miss Safina, yes, Safna is it? Yeah, Miss Safna. And the title of Miss Safna's paper is Imprisoned Women.
Hello, ma'am. Am I audible?
Yes, ma'am. Yes, Safna.
Okay. I have a request that I'm not able to turn on my video as it would interrupt my audio connection. Can I? Okay.
Yeah, sure.
Thank you for everyone for having me here today and giving me this opportunity to be a part of this scholarly platform. My paper is on female prisoner and it's entitled as Imprisoned Women, Invisibilization of Female Prisoners in the Elimination of Legal Protection. We have seen and read a lot of movies and books, but most of our filmy imaginations of prison mainly illustrates two images. One is a muscle and bloody merciless criminal, and the later is one who is spending their miserable life in cells with a pain and isolation. But when we analyze about what's peculiar about these two images, we get an answer that there is a complete absence of women pictures in prison. Their existence, pain, memories, and everything are unheard or neglected deliberately as they are not convenient to the male-inspired imagination. So women prisoners are usually discriminated against due to the fact that prison and prison routines are mainly developed with the needs of majority of male prison population in mind. As we can say that according to the opinion of Nicola Hunt Rafter, he says that women are classified by criteria designed with men in mind. So only recently, sociologists and historians alike started to inquire into the problem of women offenders and victims. Earlier, it was limited on the ground of explanations like women are inherently less inclined to criminal behavior, women are selectively diverted away from criminal sanctions, and women are less inclined to forms and patterns of criminality. So there are some explanations. Great emphasis on the so-called biological and psychological factors. We all know that in India, there are various kind of gendered and stereotypical roles structured around women's lives. So women are expected to be well-behaved and morally mature, domestic happy women within the patriarchal roles. Moreover, if they slightly violate all these so-called nations, they would end up in a degraded and often vulnerable position in society. Also, we know that during the COVID pandemic, there are reports saying that domestic violence and abuse against women are increasing within the household. Domestic violence and any other form of misconduct from inside are generally welcomed as a part of making women into more obedient according to the unwritten social code of law. When women begin to change these stereotypical position and violate the existing norms, society begins to see them evil. So we can, for instance, we can say that today itself that women may face harsher sentences because of perceptions that only bad women commit criminal offenses. It is also crucial to look at in which circumstances women commit crimes. So besides their case records, there are plenty of past painful memories left aside. Women's pathways to prison are often marked with a damage to childhood, intimate partner violence, sexual abuse, familial estrangement, addiction, and violence. Women also who faces economic marginalization because when we analyze the nature of crimes committed by women, they are like robbery, theft. So there is an economic background for women crimes that women who face economic marginalization themselves forced to commit crimes where her sole option is to make a living. So also within the prison regime, one could see a kind of discriminatory treatment or social categorization from the inmates and prison staff according to the nature of her offense. For instance, in Of Women Inside, Prison Voices from India talks about Saloni, who has been for immoral trafficking, says that, I know that Saloni has been arrested under the Prevention of Immoral Trafficking Act. So I also know that if a woman is in prison for a sexual abuse or as a law would label it, immoral trafficking, she doesn't stand a chance of being accepted. Also, one can see a kind of re-victimization and a re-traumatization in the prison regime. So, for women with the previous histories of abuse, prison life is apt to simulate the abuse dynamics already established in these women's life, and it further led to perpetuating a kind of re-victimization and re-traumatization in her life. There is a kind of, when we analyze that, there is a kind of prison power dynamics that are shaped by the structural distinction between those in power, like prison staff and prison administration, without power, the prison inmates. As a result, this structural distinction serves as a constant reminder to women in prison that they do not have autonomy over their own bodies or well-being in prison because privacy and feeling of space always strictly scrutinized in prison by the prison administration. So it led to her a certain feeling of powerlessness over her own body because there is no space even to cry and even to express her emotions in the prison regime. So as a result, these previously traumatized women choose to avoid the gaze of males in order to create a safe place. But they are forced to live in a situation where male officers are constantly present. It might include their most personal and private activities at any moment. So these women can develop a generalized fear, and it led to them a kind of psychological trauma. So they are always aware or either afraid about the constant experience of exploitation. This, along with their horrendous past memory, haunts them in their entire life. Surveillance and security system in prison violates every sense of women's privacy by sneaking into their cell, toilet, and even inappropriate checking of her private parts. One of the prisoner, Leela, recalls that in addition to the regular lack of privacy, there was a time when the authorities at Baikula prison decided to go to a step further and install CCTV cameras inside the women's barracks. She said, it was fine with the cameras in the outside areas, in the corridors, but not inside the barracks. It would get very hot in the summer. We often slept with very few clothes on. So This is a situation that kind of necessity in the prison regime. So we can see kind of deliberate invisibilization of female prisoners. So like that, women prisoners were either condemned as weak or immoral creatures by the society. At the same time, there are news channels and newspapers who got upon before after the exclusive news, especially for women involved in a certain crime. They will even engage, they will even interfere even her family matters, even her private matters. So, but what happened once they entered into prison enclosures, they were deliberately faded into oblivion. But so none of them would ever take interest to check on what her situation now in prison. So also, what about the majority of women present in jail? It is actually they were totally ostracized. They had neither remembered nor appeared in any of the public concerns. That's the reality of the most of the female prisoners. Like Shamim Modi, who was arrested amid of a string of tribal protests, says that there is no contact with the outside world. There is often so much abuse that you don't feel human. It can make you forget you ever had rights. So moreover, correctional bureaucracies are staffed mainly by men. These officials are less sympathetic to the needs of females and male prisoners, and they tend to find women's institution last because we know in India most of women prisons are stand in the excess of male prisons. So the most prisons are insanely crowded due to the lack of adequate housing with insufficient toilets, showers, and other basic sanitation and hygiene facilities such as water and menstrual hygiene products. The authorities at Presidency Correctional Home in Kolkata measure the women's bodies and assign a sleeping area just that size to fit 45 women in a row, so small that it needs only one bed one fan. One among the inmates in Kolkata's Presidency Correctional Home says that each month menstruating women were given 12 sanitary napkins. If your flow was heavier and you needed more, they just gave us gauze bandages and cotton, and we had to make our own napkins with that. For disposal, there was just one bag and it wasn't properly cleaned and treated. There was already a paper relating to the lives of children of incarcerated women. So they were like we can say they were the offense of justice. Now I'll just mention about the type of rehabilitative and vocational training given to women prisons. Women prisons offer courses in cosmetology because they are cheap, but also because it is assumed that women more than men need to pay attention to appearances because by giving this kind of training, that is like grooming, cosmetology, it cements traditional roles of women again. Also, the rehabilitative training mainly taught them how to sew. But all these efforts have little result as all these women go through stigma and abandonment both from their families and public. Because after the release, they have no support. Even they also lack the legal and familial support. If there is no roof over their head, what's the need of all these training and employment capability? So women are continued to haunt from scars and they deny the comfort of both psychological and the social support. And a big issue is also the consciousness of the law and practiced by women prisoners. During COVID outbreak, a 23-year-old woman and her 1.5-year-old daughter had to spend 2 months in Tihar jail despite being charged without arrest. It was because of her lack of legal awareness and adequate support as she is from an uneducated poor background. So the escape of 2 prisoners from women prison in Kerala broke into headlines. The incident revealed that the women arrested for theft choose to take a risky step as they lacked legal awareness. They believed that they would be forced to spend their entire lives in prison as they had no one to secure bail. It broadened the already asked but entirely ignored questions on women prisoners' welfare and her awareness regarding various legal schemes and protections. Many women in the justice system are from poor and marginalized sectors of communities or from societies where the education of women is not the norm due to role models imposed on the female gender based on religion, custom, or stereotypical perception of women's position in society. So a large majority of women who are detained not only do not have the economic means to hire a lawyer, but they are very often illiterate and unaware of their legal rights. So this places them in a particularly vulnerable position at risk of signing statements that have serious legal implications and of being open to coercion. At the very least, the lack of legal representation can lead to immense delays in the criminal justice process and fewer chances of defendant being considered for bail. As Flavia Agnes opined that lawyers are not very keen on taking up free cases because there is no money. They don't visit the jails as frequently as they should. This create awareness about the legal rights to female inmates. They take up cases where they can draw good money. She further opines that the majority of the women are convicted for cases like theft, domestic violence, and human trafficking, and they belong to the economically poor families. And the families are not keen on taking money on women and helping her secure a bail. Like also, Meera pointed out that women prisoners are entitled to free legal aid. They will get aid if they ask, but many women don't ask because they suffer from lack of awareness about their rights inside jail. And when the lawyers visit, they just skip the session. So, for conclusion, that we know that prisons are strictly sealed off from the public, and also the misconception regarding crime and punishment for isolate its inmates from outside world. So disparities in the management of female prisoners should be reformed according to the adequate mental and physical needs of women. Also, correctional officers and staff should be educated and empathetic towards women needs both mental and physical. It is also inevitable to inquire into the roots of women's circumstance in which she dared to offend the law. So the vocational training and rehabilitation program should have a positive effect on women and would enable them to rebuild their life after release. So we should much ensure that enough familial and mental and legal support reach to women completely. So this is my paper from. Thank you all.
Thank you, Safna. We proceed to the next presenter, Mr. Shikhar Bharadwaj. He is from National Law University, Himachal Pradesh. And the co-author for his paper is Mr. Rohit Katara. The title of the paper is Male Acid Victims, Acid Attack is a Gender Unbiased Crime. Mr. Shikhar Bharadwaj, please kindly present your paper.
Good morning, teachers. Before I begin with my paper, I would like to thank the organizers of this webinar for conducting such an esteemed organization in such tough times and giving us the opportunity to present our views on the papers. My topic is Male Acid Victim, that acid attack is a gender unbiased crime. Now, the attempt of this paper is to embark that the concept of acid attacks or acid victims in the society and media platform has always been recognized towards as a female targeted crime, something like female foeticide or dowry death, which, if we follow the recent trend of the last 10 years, is not the case. Acid attacks have become a general crime like theft, robbery, or murder, which could be targeted towards gender neutral accused, towards the gender neutral victim by a gender neutral accused. And we as a society, as lawmakers and as law students need to appreciate that this concept of understanding acid attack as a gender neutral crime is a need of the hour, so that we can make better laws and we can control the attacks or we can control the crime in a better way. In support of my argument, I have got a lot of research on the real victims of acid attacks from India, which are male, and study of the London-based survey of various NGOs. Before I begin with the paper, let me also make it very clear to the Honorable Chair that the paper does not disregard the female acid victims in any case. The attempt of this paper is to provide male acid victims the equal pedestal to represent themselves and get the rights from the courts of law which they are denied. The attempt of paper is in no way to derail the female acid victims in any manner. Now I begin with my paper. Beginning, in last 2 years in Britain, there have been 74% cases where the male has been a victim and 67% of the cases where male has been the accused. And recently, following these trends, there have also been cases where both the parties have been females. The accused and the victim, both the parties are females. This is a survey conducted by a British-based survey agency, which is known as Fight Against Acid Attack, which conducts a survey 2 years in every 2 years. This is the report of 2018, because in 2020 the survey was not conducted because of the pandemic. The report which I have is of the year 2018, which states that in 67% of the cases, the acid attacks have been by the victim who has been male. Coming to India, the Acid Survivors Founders India, ASFI, an NGO based in Kolkata, West Bengal, which worked toward the prevention of acid burn violence as well provide support services to survivors, conducted a study in which obtained results were quite shocking. It was found that over 29% of the victims in India of acid violence have been taken. Yes, sir?
Yeah, please continue, Shikhar. Please continue.
Okay, thank you, ma'am. Thank you, ma'am. Yes, so I was talking about the report conducted by ASFI, which shows that 29%, more than 29% of the acid victims in India have been male. This was also supported by the conduct of SAA, Stop Acid Attack, a Delhi-based NGO, whose survey report also shows that more than 22% acid attack victims in northern India or in region around Delhi is male. Let me quote the statement given by AFSI Joint Director Ms. Anita D'Souza. She highlights that in cases of acid attacks on men, the reasons are basically revenge, jealousy, or property matters. So acid attacks are not merely something which could be related to male's ego or in any way only be associated with relationships or modern relationships. Acid attacks could also be associated with crimes of revenge, hate, jealousy, property matters, or in some way a deliberate attempt to hamper someone's physical condition. First, I would like to highlight the case study of Mr. Firoz Khan, who is a Calcutta-based sweeper, a 42-year-old sweeper. When he was 27-year-old, a scuffle took place in his neighborhood between his brother and his neighbor. He participated in this scuffle and tried to fight with his neighbors. In an attempt to fight, his neighbor threw a bucket full of acid with a mug on him and on his brother. Firoz saved himself but got some grave injuries by rushing towards a community hand pump. But the damage was already done. 15 years later of this case, despite being the victim, he has been made to go to the court hearing at Tees Hazari Court every month as an accused. Because the case represented makes it very clear that Firoz Khan was the one who threw the acid. Despite he has burn marks on his face, the case presented by the other party makes it explicit that the Firoz Khan was the person who threw the acid, and he is appearing for the last 15 years in Tees Hazari Court as an accused. His petition of being the victim will be heard later once he is being discharged of all his once he is discharged of all the charges made against him. He says his lawyer, Mr. Manoj Bhandari, quotes, "We have decided to move to the higher court, but it will easily take 5 to 6 more years for the work done." So now male acid victim, Mr. Firoz Khan, nearly had to wait 20-25 years to get justice. This is the case when no media, no government organization, no NGO in any way has helped him to get the legal recourses. He has sold his shop to pay the fees of the lawyer. And now Mr. Lawyer Manoj Bhandari is even doing pro bono services for Mr. Firoz Khan. Coming on, a very important case study is of the cases where females are the accused and males are the victim. This has been supported by the Noida-based lawyer, Mr. Dinesh Singh, who quotes that a few years ago, such cases were unheard of. But now every month or so, we hear at least one such incident. Girls are getting more assertive, but not always in a good way. Most such cases are reported from the urban areas of the state of Delhi. Firstly, these cases aren't as prevalent as harassment and attacks by men, so we can't equate them. But even then, many male acid victims are wary of filing police complaints due to the fear of being ridiculed. Last statement which I'm getting to quote by the statement of Dinesh Singh, he says, they say, the victims, the male acid victims say that the concept of being harassed by a woman is in itself very embarrassing. And to get away from this embarrassment, most of the male acid victims whose accused are females usually don't file an FIR or usually don't report. Now coming on another case study of the youngest acid survivor, which is a 2.5-year-old boy. A 2.5-year-old boy was subjected to acid attack. This was again the case of revenge. His uncles were jealous of his father, and in attempt to hamper or damage his father in any way, they threw acid on a 2.5-year-old boy. This case was taken again by the Supreme Court, to the High Court of Delhi. But again, as they say, it has been 9 years that this case is yet to get its verdict. His left eye doesn't shut anymore. He sleeps with his left eye open, says the mother of the 2.5-year-old boy. Concluding my research paper, I would like to highlight that the lawmakers, when they substituted section 326A and the section 326B in the year 2013 for the betterment and to bring justice to the male acid victims, the section states, whoever causes permanent or partial damage or deformity or burns or maims to disfigures or disables any part or parts of the body of a person or causes grievous hurt by throwing acid, on administering acid to that person, or by using any other means with the intention of causing or having knowledge that he is likely to cause such injury or hurt, shall be punished with imprisonment of description of a term which shall not be less than 10 years. In the section, unlike the rape section, it is nowhere mentioned that this section only indicates toward the female acid victims. The language of the section is gender neutral. So why, as the lawmakers, why as the law practitioners, and why as a law student, and why as a society, we are yet not able to digest that the acid attacks are a gender neutral crime. And the male acid victims also need equal support from the society, equal love from the society, equal affection, equal legal resources from the society, which the female acid victims get. Reading section 326B with the same language, again, does not implement in any way any right towards women only. The language, again, is gender neutral. So when the lawmakers assign this act section to be gender neutral, why is this the analogy of the media, analogy of the legal practitioners or the advocates who are even giving pro bono advices, pro bono services to the legal victims? Don't give pro bono services to the male acid victims. In most of the cases, male acid victims do not get pro bono legal services. So this paper aims to question these things in the society, and it highlights the plight of the male acid victims who are not even given equal pedestal in the society by the people who have been made, or the authorities who have been made in charge of providing justice to the society. Again, I would like to cite that be it male or a female, when the crime is gender neutral, the treatment of the victim should be so. Thank you very much. Thank you.
Thank you, Shekhar Bharadwaj. It was a really interesting paper, and certainly Dr. Priyadarshini applauded, and we all do that for you for getting us to a very different side of human rights and to a topic which was a very unconventional one. We go back again to Miss Arshita Anand.
Yes, ma'am. Am I audible right now?
Yes, dear, you're audible.
Okay, ma'am. I will be sharing my screen. Is that okay?
Yes, you could.
Okay. Just a second.
Arshita Anand is from Chanakya National Law University, and the title of her paper is Reproductive Rights of Women in India.
Yes, ma'am. Just a second. Are you able to see my screen?
There is a gray block. Could you just hold on for a minute? Yes.
Just a second, ma'am.
Yes. It's a Word doc, right?
No, ma'am. It's not a Word doc. It's a PowerPoint presentation.
Ma'am, you're sharing a Word doc then. Share.
Yes, just a second, ma'am.
The time being, I welcome Dr. Deepa Sharma, Principal of Sri M.D. Shah Mahila College, who has joined us for this technical session.
Yes, ma'am. Is it visible right now?
Good morning.
Good morning, ma'am. Yes, Arshita. Yes, just for a moment.
Let me know if it's visible.
Yes, it is visible. Arshita, it is visible. You could continue.
Okay, ma'am. So, ma'am, my research topic title is Reproductive Rights of Women in India, and I'm from CNLU. So we see that that India has been stigmatized with faulty healthcare system, especially when it comes to women. The society is structured in a way that women do not have much to look forward to, despite the fact that the government has several stringent laws aimed at the well-being of women regarding reproductive rights. This research paper discusses reproductive rights of women in India with respect to cultural background and socio-economic aspects, efforts by the government to sensitize people regarding it, the various laws, the policies applicable, and other measures to improve the condition of women in India. So let's see that what you see on the screen right now are the reproductive rights that were issued by the WHO. Since there is a paucity of time, what I am trying to bring out here is that our constitution, the Indian constitution, tried to adopt all these rights that were issued by WHO for the betterment of women welfare in India. Hence, we have the Article 14, 15, and 21 as our fundamental rights that stand for the right to equality, non-discrimination, and the right to life. Other than that, India is also signatory to numerous international conventions, all of which recognize reproductive rights of women in India. However, we need to understand what the Indian social structure is. So we see that how India majorly has a patriarchal setup, and this leads to people having unprotected intercourse, women not knowing their legal rights, and society backing off from taking measures to improve reproductive health. Sadly, this patriarchal setup is also seen in terms of sterilization programs, where men barely participate because it's basically the women who would be facing the problem of pregnancy, right? And this is a mentality I think we need to change as a country. When we talk about the courts in the Indian setup, we see that the courts have been highly progressive on the women reproductive rights. So as with reference to that, we have Navtej Johar judgment that decriminalized adultery and homosexuality because women have a right to sexual autonomy. The Puttaswamy judgment held that the women could make their own reproductive choices under the ambit of Article 21. Then there was another judgment named Independent Thought versus Union of India, which held that the reproductive rights guaranteed to girls should be guaranteed to girls whether they are married or not, and they deserve recognition and acceptance. Understand that all such reproductive rights are under human rights, like right to life, right to health, right to non-discrimination, right to protection from gender-based violence. Then several of these fundamental rights are provided through Part 3 of the Constitution of India. Hence, we see the Permanent Katara versus Union of India, where Supreme Court stated that Article 21 makes it obligatory for the state to preserve life. Other than that, there are several more judgments which have been mentioned in my research paper as well. But given the scarcity of time, I would skip that, coming to the main provisions that my research paper holds. So what my research paper has is that I have divided my research paper into 4 major parts, that is abortion, surrogacy, maternal health, and contraceptives, and the flaws that the country has with regards to these. So when we talk about abortion, the Medical Termination of Pregnancy Amendment Act 2021 allowed women to abort their children as a part of their reproductive rights and gender justice. This was a good bill overall. However, what it did was that it raised the upper limit of MTP from 20 to 24 weeks for women. That only includes minors, rape survivors, differently abled women, and victims of incest. Meaning to say, if if you wanted to get an abortion, you could not do it until and unless you came under these categories. So this is one flaw that the MTP has, the Medical Termination of Pregnancy Bill has. However, before this, MTP was available only for married women or her husband, but with this bill, this is now available to any woman or her partner. And the problem here is that the gestational age limit has been struck off in the case of an abnormal fetus. This ensures that the women do not have to run courts to seek permission while their health is in danger. However, the problem is that the medical infrastructure of the country is not supportive enough. So we see that the 15.6 million abortions occurred in India in 2015, out of which only 22% were obtained in health facilities. This is mostly because unwanted pregnancies are a taboo topic here, and so women prefer aborting their children by any other means than to actually go and see a doctor, or actually go and discuss this problem with other people, just because it has become a taboo topic in our country. Next we come to the surrogacy bills. So the surrogacy regulation bill 2020 allows any willing woman to be surrogate. The problem here is that this bill denies the opportunity of having a child through surrogate mother to LGBTQ persons, live-in couples, and single parents. Even those included within its ambit are required to have a certificate of essentiality, stating that it is biologically impossible for the person to have a child in any other way. Medical conditions that do not render a woman infertile, but also but might make pregnancy riskier, are more complex and are not considered under this act at all. Surrogacy opportunity is also not given to women who do not want to undergo pregnancy due to the career-related commitments. So these are certain kinds of the amendments that the bill should have, but it does not have. So I believe that had these regulations been under control, or had these regulations been amended properly, these are certain kind of amendments that should have been there, because given that we allow our women to be free as a country, right? So this will also bans the commercial surrogacy through owing to the ethical sides that the country has. However, the country still runs a large unregulated market for surrogacy industry, where you can actually buy the womb of a willing woman. Details of this industry, specifically that of Anand City in Gujarat, was published in a reputed newspaper, Dainik Bhaskar, and is mentioned in my paper as well, if you could go through it. But this is basically what the problem lies with the surrogacy bills. Next, we come to when we talk about contraception, we see that how in India the burden of contraception still falls on the women, right? So like 3 in 8 men believe that contraception is women's business and that men should not have to worry about it. Moreover, about 20% of the men believe that using such contraceptive methods makes a woman promiscuous. Hence, even though measures like the usage of condoms are much safer and easier, it is the women who have to take the hormonal pills or IUDs instead and deal with the consequences of its usage. Male sterilization is opted only by 0.3% of the married couples, where female sterilization is at 36%. The patriarchal setup is so grave that 56% of the men said that their wives could not use contraception without their permission. Men also believe that such measures decrease their manliness and libido and reduce physical strength. So the stigma related to contraceptive measures is such that the workers responsible to disseminate information on family planning are almost entirely female. This includes ashas, anganwadis, or auxiliary nurses and midwives. They do not approach the male members of the society due to the social stigma. Thus, their interaction is mainly limited to women. This results in men getting their information on contraception mostly from informal sources, which are not even credible. The government is also at fault here, because 80% of the funds available for the family planning is focused on surgical and mostly non-reversible methods of preventing conception, specifically female sterilization. The government does not even care about that men could be sterilized also, because essentially the government has taken into consideration the patriarchal setup that the country has and is burdening the women with with their sterilization programs without taking any advertisement campaigns for the men on and whole. So these are the problem when we talk about contraception. Next, we come to the maternal health. We see that India has made considerable progress in improving maternal health in the past 2 decades. UNICEF has worked with the Ministry of Health and Family Welfare, Ministry of Women and Child Development, Niti Aayog, and state governments to ensure the same. Ministry of Health and Family Welfare launched the Pradhan Mantri Surakshit Matritva Abhiyan. It provides a fixed day for quality and assured antenatal care to pregnant women free of cost on the 9th of every month. It helps in the early detection of high-risk pregnancies, thus reducing the maternal mortality rate in India. Another initiative taken was a Janani Shishu Suraksha Karyakram to provide completely free and cashless service to pregnant women, including regular deliveries and cesarean operations, and sick newborns up to 30 days of birth in government health institutions. However, the problem here is that these were not advertised properly, so people are not even aware of these programs being run throughout the country. It has been held. There was a case of Lakshmi Mandal. It is mentioned in my research paper that it was held that the right to health includes the right to access and receive a minimum standard of treatment. Then there was also a PIL of Sandesh Bansal versus Union of India that seeked accountability for the maternal deaths filed in 2012. There, the court held that the inability of women to survive pregnancy and the childbirth violates the fundamental rights to life as guaranteed under Article 21 of the Constitution of India. Hence, again, the problem is that of advertisement. People do not know that these programs are even running throughout the country. They do not know that these programs exist, and hence they cannot even benefit from these programs. And that is a very sad reality that the country has. And I believe that it is time that the government takes control of what campaigns that they're advertising. So coming to what the government can do actually with regards to all these problems, I believe that there should be a fourfold problem solution management. Number one is a policy framework. I believe that the policies should be framed and advertised properly for pregnant mothers to register themselves at the nearest health centers for the provision of antenatal care as soon as they're aware of their pregnancy. It ensures that the identification of high risk issues and proper care of the to-be mothers and their children, which would further reduce the maternal and infant mortality rates. Secondly, I believe that measures should be taken to advertise the present laws and rights of women on maternal health, because as of now, women are not even aware of the rights they hold with regards to maternal health, and that is a very, very sad reality that the country has. Thirdly, I believe that the striking patriarchal roots is something that is extremely important in the present context of the country. So we, as we already see that the country is burdened with a huge amount of population. We often see couples in rural areas having 8 to 10 children just because marital rape is a common norm there, and men would essentially not take efforts to better something they do not personally have to suffer. Hence, I believe if a policy is implemented that requires men to undergo sterilization after the birth of their third child, physical barriers like condoms would start being used in several rural areas in that case, because then the people would not want to undergo surgical procedures if the problem could be fixed alternatively. Again, this is a very twisted kind of mentality, but it needs to be implemented, because we see that this exactly is the patriarchal setup that the country has. Men, even if you go into rural areas, men do not care about their wives, because and you could see women, going into labor for 8 or 10 times. They have 8 or 10 children, just because men did not want to use any protection during their intercourse. So essentially, it all boils down to how, since men do not have to suffer through pregnancy, is why they are not taking any such measures. Fourthly, and most importantly, I believe that male targeted sterilization advertisement campaigns is something that is very necessary in today's in the present country's context. So we see that the government sterilization advertisement campaigns are highly aimed at women in today's era. That 80% of the government's fund for these campaigns are directed at women advertisement campaigns. So I believe that if male targeted family planning campaigns and advertisement of a wider range of male contraceptives and male health workers get deployed to deal with men, it could change the current scenario that we have, the current patriarchal setup that the country has. That's all, ma'am. Thank you.
Thank you, Ishita, for your presentation. Before we move ahead to the concluding remarks, I request the panelists if they want to ask any questions to the presenters. To start with, we do have a question. Madam Dixit, could we go for the question answer session?
Yeah, sure, ma'am.
Yes.
Yeah, you can open for the discussion, ma'am. No issue.
Yes. There's a question from one of our panelists, Dr. Prabha Ravi Shankar, and this question is for Miss Ishita. Miss Ishita isn't in the panel. I think she has left. I'll just check if she's in the attendees. Meanwhile, Dr. Ranjana Mishra, if you have any questions, please kindly unmute yourself. Ma'am, please kindly unmute yourself. Ma'am, you need to unmute yourself. Dr. Mishra, please unmute yourself.
Yeah.
Yes, ma'am. You're audible now.
Yes. I have questions to quite a few of them. So my first question is to Miss Isika Bushi. Is she there?
No, ma'am. I'll just get in touch with Ishita.
Then Miss Kalyani, are you there?
Yes, Miss Kalyani is there. Miss Kalyani?
Miss Kalyani?
Yes. She's also. Miss Kalyani, I can see her here in the panel, but
yeah. So can I? But she's not there.
Yeah, she isn't answering.
But I think she raised her hand, ma'am.
She did, ma'am.
Yes.
She is there. She's visible on screen. But ma'am, any questions for Safna? Okay. Safna is with us. Safna and Harshita Anand, I can see.
Okay. Safina, yes, I want to ask Safina. Safina, are you there? Are you there, Safna?
Miss Kalyani is here, ma'am.
Sorry, ma'am. Sorry, Miss Kalyani.
फर्स्ट ऑफ ऑल मैं आपको कॉन्ग्रेचुलेट करती हूँ, आपने बहुत अच्छा पेपर पढ़ा, लेकिन मेरा एक दो सवाल आपके सामने था। एक पहला सवाल था कि क्या आपको पता है मिथिला में दरभंगा में सौराठ मेला में शादी का रजिस्ट्रेशन होता है, पता है? लेकिन उस रजिस्ट्रेशन के बाद भी वहां पे महिलाओं की स्थिति काफी, क्योंकि खुद मैं मैथिल हूँ इसलिए आपसे ये सवाल कर रही हूँ कि रजिस्ट्रेशन के बाद भी ऐसा नहीं है कि महिलाओं की स्थिति बहुत अच्छी है। तो क्या आपने उन महिलाओं को जो वहां पे उनका पंजीकरण कहते हैं मैथिली में, तो हुआ है, क्योंकि आप तालिका माझी भागलपुर से हैं तो आपको ये पता होगा, तो आपने जरूर इंटरव्यू लिया होगा। तो आपने क्या उनको इंटरव्यू लिया था?
मैम, मेरा एरिया ऑफ स्टडी है बांका ब्लॉक।
और मुझे दूसरा एक सवाल आपको पूछना था कि बहुत सारे राज्यों में रजिस्ट्रेशन होता है, फिर भी महिलाओं की स्थिति, क्योंकि आपने दिल्ली का रेफरेंस दिया, ये दिया, तो वहां भी स्थिति खराब है। तो रजिस्ट्रेशन है, इट्स नॉट दैट इट शुड नॉट बी देयर, लेकिन उसके बावजूद स्थिति क्या बहुत अच्छी है? तो क्या आपने उन महिलाओं को इंटरव्यू लिया जिनके पास रजिस्ट्रेशन था और उनको राइट्स मिला, और जिनको नहीं था और उनको राइट्स नहीं मिला?
यस मैम, मैं तो गई थी अपने एरिया ऑफ स्टडी में, तो वहाँ पे मुझे दिखा कि मतलब मेन है कि पढ़े लिखे कम है मैम। सबसे जरूरी चीज है कि वहाँ पे एजुकेशन नहीं है, और एजुकेशन नहीं होने के वजह से ये सब हो रहा है। उन्हें अपने राइट्स कुछ पता ही नहीं है। मैं तो जस्ट लाइक मैंने क्वेश्चन आयर वगैरह मेथड यूज किया था उसमें, कि उससे जाके पूछूं, तो मैं पूछी, लेकिन जेंट्स लोग तो मतलब उन्हें पता ही नहीं है कि ये रजिस्ट्रेशन होता है क्या है, इससे क्या करना है। वहाँ पे मेन बाल विवाह बहुत ज्यादा हो रहे हैं। वो कहते हैं हमारा ये कस्टम है कि लड़कियों 15 इयर्स होती हैं, उनका बस शादी कर देना है। वो एक अपना एज ऑफ मैच्योरिटी ले लेती है, तो बस उनकी शादी कर देनी है। तो ये सब उन्हें बिल्कुल नहीं पता है मैम। तो आप देख रहे होंगे हमारे गवर्नमेंट भी इसके लिए कितना कुछ कर रहे हैं, बेटी बचाओ बेटी पढ़ाओ, ये सब काम कर रहे हैं, जिसके तहत वो जान सके कि सही क्या है गलत क्या है, ये सबको रोका जा सकता है। तो मैं लेडीज लोग से मिली और उन्हें बताई कि आपको करना क्या है। अगर आपको कुछ प्रॉब्लम, मान लो वहाँ पे पॉलीगैमी मोनोगैमी ये सब बहुत ज्यादा है वहाँ पे, एक्स्ट्रा मैरिटल अफेयर्स बहुत ज्यादा होते हैं। तो मैं उनसे ये बात बोली कि आपको ये सब पता है, फिर भी आपको पता है कि अगर वो दूसरी मैरिज कर लेंगे तो फिर आपका क्या होगा। तो उन्होंने बताया कि हाँ मुझे तो ये सब नहीं पता है। तो अब वो जाके मतलब बताने पर वो समझ पा रही हैं, क्योंकि वहाँ के मुखिया लोग भी इतने एक्टिव नहीं है। तो बता रही हूँ, अभी तो ये चल ही रहा है मैम मेरा ये सर्वे का।
थैंक यू सो मच कल्याणी। कोई दूसरे को भी अगर उनसे क्वेश्चन पूछना है। अभी Miss Ishika Bushi, are you there?
He's not there.
Yes, ma'am, I am there.
Okay. Ishika, I just wanted to ask you, have you ever visited, Pyongyang and Khartoum?
Ma'am, I can't hear you. You're not audible. Have I ever visited what?
Have you ever visited Pyongyang and Khartoum?
No, I have never visited, ma'am.
So, and my another curiosity, that means your paper is based on secondary sources.
Yes, ma'am, my paper is based on secondary sources.
Okay. And second question that I wanted to ask you, what made you select these two countries? Like one from Asia, one from Africa. Like there are so many countries. That is just my query.
Yeah, curiosity. I understand, ma'am. The reason why I chose one from Africa and one from Asia would be because North Korea is something we hear about in our daily lives. Something about North Korea going on. We keep hearing the mention of the president's name every now and then. So I was always curious to know what is going on in North Korea, since there are not much sources that tell us exactly. So when I was researching upon it, that was one area which I found really interesting. So I chose North Korea. And other than that, I would say why I chose the country Sudan would be because there are human rights being violated there every now and then. And when I was looking up for countries, Sudan was something, while reading about the history of it and everything else, is what something that clicked me. So I chose Sudan and then North Korea. It might sound like extreme ends, I get that out of curiosity, but yes, while researching upon it, these two countries seem to catch my attention. So that's why I chose it.
Is Arshita Anand there? Arshita?
Yes, ma'am. Am I audible right now?
Yes, very much. Can I, like at the outset, I want to congratulate you for presenting a wonderful paper, but 2-3 points like I felt like maybe because you were not that audible. First was why our reproductive rights are important. That's the thing I wanted. And what are the examples of reproductive rights? What are the examples?
Yes, ma'am. It was there in my presentation itself. However, I did not speak much over it because I was given only 15 minutes and I had a lot of material to cover. So I could start right now if you would allow.
No. Just tell me the examples that I wanted. What all things it will encompass?
Ma'am, so there should be a right to legal or safe abortion. That is something that is provided by the Constitution itself. Then there is a right to control one's reproductive functions. right to access in order to make reproductive choices free of coercion, discrimination, and violence. Then right to access education about contraception and sexually transmitted diseases, and freedom from coerced sterilization and contraception. Then right to protect from gender-based practices such as female genital cutting and male genital mutilation. These were something. Yes, ma'am.
Yes, very
Okay.
good.
Okay, so ma'am, these were something that were propagated by WHO as well, and then they got incorporated in the Indian Constitution as well through Article 14, 15, and 21. Then there were several directive principles of state policies that were involved in giving these rights. So, like we have Article 39E of the directive principles of state policy, all of which that recognizes these rights. And even with the when we talk about the jurisprudence that the courts have, so like right to life is not something that essentially words reproductive health. However, by jurisprudence it means that reproductive health is something that is inherent in right to life. So these are the kind of jurisprudence that the court shows in the Indian context.
Thank you so much, Ishita.
Thank you, ma'am.
Hello.
Yes.
Hello. Can I speak a word with the permission of the chair? I am Prabha Ravishankar.
Yes, yes, sure, ma'am.
Yeah. See, my question was also addressed to Ishita. Unfortunately, she was not there. Just to point out the question once again.
Yes, ma'am.
She yourself said, you yourself said that it is very, North Korea is very difficult to get any kind of
it is
too much
difficult
of
to
strict censorship, etc.
Yes,
is there.
ma'am.
So, what were your sources and from where and how did you manage to get it? That's number one. The other question I want to address to Mr. Shikhar Bharadwaj. Is he there? Mr. Bharadwaj, is he there? I don't think he's there. Is there?
Ma'am, I would tell you that my sources were mainly articles, which is again secondary sources. So I collected as many articles I could find on North Korea. So that was one of my areas where I, looked at it. And secondaries, it was mainly based on secondary sources. Primary sources as such, I couldn't really get because,
Even though Mr. Bharadwaj is not there at the moment, I just want to congratulate him for his good paper, because acid attack on men, to be very honest, it is only now opening the eyes of the researchers, especially female researchers, because it's already generally taken for granted that acid attack means it is on women. So I want to congratulate Mr. Bharadwaj for his paper. I also have a question, but he's not there. So, but anyhow, thank you very much.
Very correct, Prabha, because nowadays you must have read in UP also, atrocities on males have increased. So it was very much in the news. It was viral.
Correct. Thank you.
Yes. We're done with all the presentations for this technical session. I please may request the chair, Dr. Shalini Dixit, to give her concluding remarks on the papers presented for the session.
Well, thank you so much, ma'am. Well, I would say the papers, the presenters, the way they presented the papers, it was very forceful. And I would thank Professor Ranjana Mishra, ma'am, the way she asked the questions. It was very, very genuine. And it was very interesting also. And I think it will benefit the presenters also. Because she went very deep into the, I would say, into the paper, and she asked the question, and it will equally help the presenters. But regarding Ashita, I have something to say if she is here, present here.
Yes, ma'am.
Okay. Because your paper, it was on reproductive rights of women in India.
Yes, ma'am.
Yes. Your presentation, it was very good, but I would like to just ask you one thing: what you can do to protect reproductive freedom? Because the way you said that the situation, the way you said it seemed that the situation is so grim. And I would, of course, in a way, I would say yes, because you all said about the stigma also. But would you say that it's an attribute that is deeply uprooting the sociological definition and ethics of the society, because stigma manifests differently depending on legal frameworks, religious beliefs, and social and cultural context. Of course, the patriarchal setup is there, and you took and you gave some of the examples also. But what you can do to protect reproductive freedom? Do you have something in your mind?
Ma'am, what you said was entirely right. We have a social setup in our country that kind of is not favorable to women, and that's a sad reality. However, I believe that since we do not have an authority, this is not something that we have in hand. What at the max we can do as a community as a whole is to change our mentality, and that has to come from unfortunately that has to come from our male counterparts, because essentially you can harp on saying that women have reproductive rights and women have freedom, but this is the kind of society that we have, this is the kind of setup that we have, that
no, I understand, but you as an individual, suppose right now you are a student, but if you are made to make a decision, so what you will propose, what you will suggest for this? How to protect the reproductive freedom?
Ma'am, I would advertise
any
rights.
clue?
Yes, ma'am. I would advertise these all of these rights that are available in our country as of now, because this is essentially where the problem lies. Women do not know what their rights are. So as a student, what I have in hand is to advertise these campaigns, every possible right that the women have with regards to their maternal health, every possible policy that the government has provided for women. If we go on to advertise these, women would be sensitized with regards to these, and would then come to know that okay, these are the rights that are available to me, that I can avail as a woman, and as as someone who would be producing a child later on. So I believe advertisement is the key.
Will settle the issue.
Ma'am, advertisement is not the
no. I'm not bothering you. Of course, your paper, the topic which you took, it's a good topic here which you carried. So just I wanted to, because you are a student, and we love to get the thoughts from the newcomers, because it's a paper is very good. And finally, I would say the papers almost 5 papers were covered up. And it was beautifully covered by all, and I like to thank each and everyone, my panelists also, the way they carried the questions. So thank you everybody. Thank you so much. Now back to the organizing team. Thank you.
Thank you, Dr. Dixit, for joining us. It was so good to see you, and hope we meet in the physical environment very soon.
Definitely. It's my pleasure.
We take a short break of 10 minutes. We resume back. Thank you to all the paper presenters. We resume back at 11:45 sharp. Thank you very much.
Thank you once again.
Thank you all.
I request Dr. Meru Prabha, you could promote the other researchers for the next session into panelists.
Okay, ma'am.
Thank you.
Miss Manju Priya, are you there? Hello, Miss Manju Priya, are you there?
Hello, hello ma'am. I'm there. I can
Please
hear you,
call
ma'am.
your co-author. Please call your co-author.
Yes, ma'am. She's entering, ma'am. She's entering now.
Yeah, okay, okay, thank you.
Yeah.
Good day to all of you. Start another 2 minutes. I request all the attendees to please kindly join at the valedictory session today, scheduled in the afternoon. The link for your certificates will be given during the session only. So all presenters and attendees are requested to join the valedictory session, which is scheduled for this afternoon. Professor Preeta Nilesh.
Yeah,
Yes, ma'am. If you kindly permit, do we go ahead?
yes, if all the speakers are here, we should.
Ma'am, we're just waiting for Ranjana, ma'am. She's the convener for the webinar. Just a moment. Yes, ma'am.
Definitely.
Good day to all and welcome back to the 3 days international webinar on human rights. To chair the final session, that is the technical session number 8, we have with us Professor Preeta Nilesh. She presently is the Vice Principal and Dean, Faculty of Humanities and Social Sciences, Head of Department of History at Wasey College, Mumbai. She has been a keynote speaker and a plenary speaker for various conferences. She's published various research papers in reputed journals, co-edited Revisiting World War I Sanitary Insights in August 2015. She also has a book on the first English medium school of girls in the Mumbai Presidency, the Alexandra Girls Education Institutes. Her research interests include women's engagement with law, education, and civil society. She's also interested in cultural studies, festivals, fountains, food, restaurants, fashion, international relations. Professor Preeta has completed a number of postdoctoral research projects funded by University of Mumbai UGC, the Asiatic Society of Mumbai, and also been the recipient of the Avabai Wadia Postdoctoral Research Fellowship. She was invited to the United States Department to participate in a 4-week international visitor program in May 2009, during the course of which she interacted with various members of the US Senate. She was also invited to the Nordic Institute Copenhagen for a work-cum-study program in 2010, and as a professor mentor to the Dubai College of Higher Technologies in 2010 and 11. Professor Preeta Nilesh has also been invited as a speaker, resource person, and chairperson to various national and international conferences, including the University of Sacramento, California, USA, University of Fudan, Shanghai, China, Mansfield College, Oxford, United Kingdom, and the International Institute of Asian Studies, Netherlands, to name a few. She has a number of publications and national and international journals. Professor Preeta has convened several conferences, including a national conference on revisiting the First World War 2014, international conferences on epidemics and pandemics during May 2020, the pandemic turn Feb 2021, and a national conference on cricket, August 2021. Professor Preeta is a recognized PhD and MPhil guide for history, as well as defense and strategic studies, and has guided several students towards MPhil, PhD in history, as well as defense and strategic studies. This was a very short note. Ma'am, I tried to cover most of it, and my sincere apologies if I missed on anything, because it goes in pages.
I was rather embarrassed and wanted to cut you short, but yeah.
No, ma'am, it is so nice to have you, and people of such caliber will only help us to learn more and grow in a much more better manner. I welcome you to this 3 days deliberation international conference, and if you kindly permit, can I please call the first speaker, the first presenter?
Yes, if you can just give me one moment, Vijay Lakshmi. I would like to thank my dear friend Ranjana for this invitation. And I would like to say hello to senior scholar and friend Prabha, who is also here. So I feel really blessed to be around with two very, very important people who have been lights in my life as well. So with having said that, let us begin.
We are also honored to have you, Preeta. It's because of that, because of your scholarship, like we very much, apart from our friendship, we know you are such a great erudite. Once again, welcome to our conference.
Thank you, Dr. Preeta. You are most welcome to our Malad College. We are honored to have you.
I may proceed if the chair permits. Yes, I'd request Dr. Vivek Mishra from Lucknow University to kindly give his presentation. Dr. Vivek Mishra will talk on the status of indigenous people. Dr. Mishra, please.
अस्यां सभायां समुपस्थिता सर्वश्रोतायार मया नमस्क्रियन्ते। आपको समझ में आया मैंने क्या कहा? नहीं समझ में आया। यही बात मैं कहने जा रहा हूं कि वी हैव लॉस्ट आवर इंडिजिनियस स्टेटस, इंडिजिनियस क्वालिटीज एंड वी हैव बीन टोल्ड। मैं भी आपसे अंग्रेजी में बोल रहा हूं, अगर अंग्रेजी में नहीं बोलूंगा सब लोग सोचेंगे कि अनपढ़ गंवार कहीं से पहले आ गया सामने यहाँ बोलने। तो आई एम फोर्स्ड टू स्पीक इन इंग्लिश एंड द टॉपिक ऑफ माय टुडेज डिस्कशन इज status of indigenous people. Well, before we discuss this status of indigenous people, we have to question a few answers. We'll have to put some questions. First question is, as the parameters of status differ from person to person and society to society, at which level do we want to see status of indigenous people? Second question is, to raise them to befit the levels of our parameters, in our enthusiasm, should the so-called civilized world or developed world be allowed to tamper with the originality of the indigenous people and deprive them of their indigeneity? Or third thing, are we concerned about their existence, कि वो जिंदा भी हैं या नहीं है, किस हालात में? What do we want to actually discuss about this status of the indigenous people? If we want to discuss their health status, we want to discuss their socio-economic status, we want to discuss their language, their culture. If we start discussing this, all these aspects, it is not at all possible in one research paper. So before we answer these things, I would like to say, today we are discussing this issue of status of indigenous people because of our parameters. We find ourselves to be better off and more enlightened than the indigenous people. This feeling of better off and more enlightened than others has been nurtured since inception of history, and all the persons suffering from this mindset, consciously or unconsciously, out of goodwill or because of the selfish motives, tend to interfere in the lives of so thought inferior or indigenous people. To elaborate and make my point clear, I would cite a few examples from the history. The examples that I am going to quote just now, I have not mentioned in my paper, but everybody might have heard about Moses. मूसा जिसको बोलते हैं, कुरान में मूसा बोलते हैं, क्रिश्चियनिटी में मोसेस बोलते हैं। मैं आपको आज से 3800 साल पहले लेकर जा रहा हूं। वहां पे क्या था कि he started from Egypt and then he started for Israel. He was told कि you go to Israel. 612 किलोमीटर का डिस्टेंस है between Egypt and Israel, which he covered in 40 years. Not only he covered in 40 years. 6 लाख लोग उनके साथ थे। अब आप सोचिए, 6 लाख लोग अगर किसी एक जगह से चले होंगे और दूसरी जगह पहुंचने में उन्होंने 40 साल लगाए, 612 किलोमीटर कवर करने में, उन्होंने वहां की इंडिजिनियस पॉपुलेशन का क्या किया होगा? आप अभी ये सोचिए मत कि उन्होंने क्या किया होगा इंडिजिनियस पॉपुलेशन का। आई टेल यू, एज इट इज रिटन इन बाइबल, दे मैसेकर्ड ऑल द पर्संस हु डिड नॉट एग्री विद देयर एनलाइटेंड माइंड। मूसा को जो है एक नॉलेज मिली थी कि भी उसको जो है, जो भी नॉलेज मिली कि भी एक ही गॉड है, उसी को मानो, उसके अलावा किसी को मानोगे तो जो है खत्म कर दिए जाओगे। एंड दिस इज व्हाट ही डिड इन दैट 612 किलोमीटर रूट। वेल, दैट इज वन एग्जांपल। द अदर एग्जांपल इज, you must have heard that the headquarters of Christianity are Rome. 320 AD तक वहां पे पॉलिथीस्ट थे, डिफरेंट काइंड ऑफ कल्चर्स वर देयर। 320 में जब कॉन्स्टेंटाइन ने क्रिश्चियनिटी अडॉप्ट करी, कॉन्स्टेंटाइन, द वन हु बिल्ड दिस कॉन्स्टेंटिनोपल चर्च इन टर्की। आप सोचिए, रोम से आया, टर्की में उसने कॉन्स्टेंटिनोपल चर्च बनाया, जिसको अभी ये टर्किश पीपल ने वापस मॉस्क में बदल दिया है। वहां से लेकर के वहां तक वो क्रिश्चियनिटी फैलाता हुआ आया। जितना भी पड़ा, they massacred all the people and converted them to the new enlightened knowledge which they received. Same thing happened with the Greece. आप अगर प्री जीसस या कह लीजिए पहली, दूसरी, तीसरी शताब्दी के लोग वहां के आर्टिफैक्ट्स को अगर देखेंगे, बिल्कुल जीवंत मूर्तियां बनाया करते थे, जीवंत आर्किटेक्चर था उनका, लेकिन that all was demolished just because somebody told them that you are enlightened, you are more civilized. Today we are discussing, हम आज ये बात डिस्कस कर रहे हैं कि भैया हम जो है इंडिजिनियस पीपल के बारे में सोचें। हम क्यों सोचें इंडिजिनियस पीपल के बारे में? आर वी मोर सिविलाइज्ड देन देम? 200 साल बाद हमारे को, जैसे आज मैं पहले के लोगों को कह रहा हूँ, या आप ही अपनी अगली जनरेशन को पूछ लीजिए ना, वही कहते हैं कि माँ बाप को कि भैया आप लोग तो बेवकूफ हो। तो उसी तरीके से 200 साल बाद आज की जनरेशन को बेवकूफ कहा जाएगा। दे वर थिंकिंग अबाउट द इंडिजिनियस पीपल, व्हाई शुड वी थिंक अबाउट द इंडिजिनियस पीपल। अब ये पूरा कॉन्सेप्ट समझने के लिए कि भी हम लोग ज्यादा सिविलाइज है, हर एज में जो है ये कॉन्सेप्ट लोगों के दिमाग में आया कि भी वी आर मोर इंटेलिजेंट, वी आर मोर एनलाइटेंड, वी हैव मोर नॉलेज। तो ये पहले ये सारी चीजें समझने के लिए पहले 3-4 टर्म्स आपको समझ लेनी पड़ेंगी। फर्स्ट टर्म इज रोमन पॉन्टिफिक्स। रोमन पॉन्टिफिक्स क्या था कि जो है एक पोप होते थे निकोलस फिफ्थ, उनके पास पोर्चुगीज गए कि भाई हमने वेस्ट अफ्रीका कैप्चर कर लिया है, तो इसके सारे राइट्स हमारे को दे दिए जाएं। दिस वाज 1455। मैं आपको हम बिल्कुल वहां से 320 की सेंचुरी से लेकर के बीच के 1100 साल छोड़ता हुआ जो है सीधा 1455 पे आ गया हूं। पोप ने कहा कि ठीक है, आपको वेस्ट अफ्रीका हमने पूरा दे दिया। ये तो पोर्चुगीज लोगों के साथ हुआ। अब स्पेनिश भी लोग थे, स्पेनिश लोगों को थोड़ी सी दिक्कत होती थी कि भैया वो जहां जाते थे पोर्चुगीज के साथ लड़ाई होती थी। तो जो है 1492 में वो पोप अलेक्जेंडर के पास पहुंचे कि भाई हमारे को जहां जाते हैं ये लोग जमीन कब्जा करी हुई है इन लोगों ने, तो जो है हमारे को हमारी जमीन चाहिए, हम जहां पे पहुंचे वो हमें दिया जाए। अब वो पोप अलेक्जेंडर ने कहा कि ठीक है, नॉर्थ पोल से साउथ पोल की जो एक लाइन खींचते हैं, उसके वेस्ट में जितनी जमीन जो भी पड़ेगा, आप जहां जाएंगे वो जमीन आपकी। आप कभी गौर करिएगा, इंडिया में पोर्चुगीज आए और उस साइड पे स्पेनिश गए। स्पेनिश इज द मोस्ट स्पोकन लैंग्वेज। मैंडेरिन जो है वो चाइनीज की लैंग्वेज है क्योंकि बिकॉज ऑफ द पॉपुलेशन, बट इफ यू सी द ग्लोबल कॉन्टेक्स्ट, स्पेनिश इज द मोस्ट स्पोकन लैंग्वेज। तो जो नॉर्थ से साउथ पोल तक की एक लाइन खींची गई, उसके वेस्ट में जितने गए सारे स्पेनिश लोग गए। उन्होंने जहां पे भी गए वहां पे अपनी जो है झंडे गाड़ने शुरू कर दिए। टुडे बीइंग 25th of August, आप सब लोगों ने सुना होगा कि अमेरिका वाज डिस्कवर्ड बाय कोलंबस। उससे पहले अमेरिका था ही नहीं। 1498 में वास्को ड गामा डिस्कवर्ड इंडिया। उससे पहले अलेक्जेंडर ने पता नहीं किसको इन्वेड किया था, या मोहम्मद कासिम ने किसको इन्वेड किया था, या मोहम्मद गजनवी ने किसको इन्वेड किया था। नहीं, जो आपको अभी आप गूगल पे मारिए हु डिस्कवर्ड इंडिया, यू विल बी टोल्ड दैट वास्को ड गामा डिस्कवर्ड इंडिया। तो जो ये लोग पढ़ाते हैं, जब जैसे इफ आई स्टार्ट स्पीकिंग इंग्लिश, है ना, why should I start speaking English? Because we have been told your culture, your language is inferior. मैंने पहला वाक्य आपसे कहा था, अस्याम सभायाम समुपस्थिता सर्व श्रोतायार मया नमस्क्रियन्ते। जितने इस सभा में श्रोता उपस्थित हैं सबको मेरी नमस्कार। किसी को समझ में ही नहीं आया, है ना। अब मैं क्या इंडिजिनियस बात करूं। तो जो मैं अब आपको बता रहा था 25 अगस्त को, जो आज भी 25 अगस्त है, 25 अगस्त को क्रिस्टोफर कोलंबस साहब पैदा हुए 1451 में। अब उन्होंने जो है 1492 में जो है अमेरिका की तरफ जाना शुरू किया। अब वहां पहुंचे। नाउ यू हैव टू, आई विल बी कटिंग शॉर्ट ऑल द थिंग्स। एज़टेक वाज ए वेरी, और रादर से 1491 से पहले, आई टेल यू 1336 में स्पेनिश लोगों ने कैनरी आइलैंड्स रिडिस्कवर करे। स्पेन के थोड़ा सा नीचे मोरक्को से 100 किलोमीटर इधर जो है कैनरी आइलैंड्स हैं। वहां के हिस्पेनियोला जो है जनरेशन पीपल हुआ करते थे। अब उन्होंने क्या करा, वहां जाकर के कहा कि भाई जो है तुम लोग बिल्कुल जाहिल हो, है ना, तुम्हारे को क्रिश्चियनिटी के बारे में मालूम नहीं है। दे स्टार्टेड किलिंग देम। उनको क्रिश्चियनिटी पढ़ाने लगे, उनका सारा कल्चर रिमूव कर दिया। सेम थिंग, क्रिस्टोफर कोलंबस जब 1492 में अमेरिका पहुंचा, द फर्स्ट थिंग ही यूज्ड टू डू इज, जाकर के सबसे पहले क्रॉस गाड़ा करता था जिस भी जमीन पे पहुंच जाता था। एंड ही यूज्ड टू थिंक ही हैज बीन सेंट बाय द गॉड टू टीच द पीपल क्रिश्चियनिटी। वहां के लोगों को उन्होंने जो है उनका कल्चर उनसे छीनना शुरू करा, उनकी लैंग्वेज उनसे छीननी शुरू करी। एंड देन वहां की एक जो है ट्राइब हुआ करता था टियानोस, उनको 1493 में जब वो वापस आया पोर्चुगल, तो जो है वहां के कुछ लोगों को लेकर के स्लेव्स बना करके लेकर के आ गया पोर्चुगल। एंड दैट इज कॉल्ड द ट्रांसफर ऑफ ओल्ड वर्ल्ड टू न्यू वर्ल्ड। ट्रांसफर ऑफ कोलंबिया करके जो है इसको उसमें कहा जाता है। एंड फ्रॉम देयर टियानोस के साथ क्या करते थे कि भी वो कहते थे ये सब ह्यूमन बींग्स हैं, इनके पास सोल नहीं है, इनके पास कल्चर नहीं है, दे आर बेस्टियल पीपल। तो इनको मारने में कोई दिक्कत नहीं है, रेप में कोई दिक्कत नहीं है, इनके बच्चों को किडनैप करने में कोई दिक्कत नहीं है। अगर किसी टियानो ने किसी क्रिश्चियन को मार दिया तो एक क्रिश्चियन की जगह 100 टियानोस मारे जाते थे। उनका एक उन्होंने रिचुअल बना लिया वहां पे कि 13 टियानोस को जो है रोस्ट करते थे फॉर देयर जीसस द रिडीमर एक, और 12 उसके अपोस्टल्स के लिए उनको जिंदा रोस्ट कर दिया करते थे। इस तरीके से जो पॉपुलेशन जो है 1491 में उनकी, आई टेल यू इट वाज समवेयर अराउंड, वेल बाय 1491-92 में वो लोग वहां पहुंचे, एंड बाय 1550 यानी कि मिड ऑफ 16th सेंचुरी टियानोस पीपल वर वाइप्ड आउट फ्रॉम देयर लैंड, खत्म हो गए वहां से। उसी तरीके से Spanish people were impressed by the simplicity and friendliness of indigenous people of America. You must be knowing that Aztec and Mayan civilization were quite developed civilizations. Aztec people knew around 1200 species of herbal plants, जिसको कि स्पेनिश किंग ने अपने फिजिशियन को भेजा कि भी वहां से सीख करके आओ। पता नहीं कितना सीखा कितना नहीं सीखा, लेकिन the biggest pyramid of in that built by those Aztec people, and that in that Mexico जो country है वहां पे, that was destroyed by the Spanish people, and the Lady of Church of Remedies, Church of Lady of Remedies was built in that Mexico. तो वहां पे आर्क बिशप पहुंचे, आर्क बिशप जुमरागो, he himself claims that in 1551 he destroyed 500 temples and 220,000 icons. They demolished the total culture of America. North America में Aztec civilization उन्होंने पूरी demolish कर दी, South Africa में Mayan civilization पूरी demolish कर दी, पेरू में Inca civilization थी, that was totally demolished. So this pattern that continued throughout this अमेरिका एंड अफ्रीका। आप अफ्रीका में अगर हर्बर्ट स्पेंसर की किताब पढ़ लें आज की तारीख में जो उसने लिख रखी है, पता लगा कि ईसाई और जो है मुस्लिम, दे आर फाइटिंग विद ईच अदर टू टीच देयर रिलीजन टू दोज इंडिजिनियस पीपल, डिप्राइविंग देम ऑफ देयर इंडिजिनियसिटी। वेल द चेयरपर्सन प्लीज टेल मी इन बिटवीन कि हाउ मच टाइम डू आई एम लेफ्ट विद, सो आई विल कट शॉर्ट व्हाटएवर आई एम सेइंग।
Ma'am, we need to unmute. So you have 7 minutes to go.
ठीक है। When Portuguese reached Brazil, the indigenous population was 50 lakhs. By 20th century, they were reduced to less than 2 lakhs. अब 50 lakhs से ब्राजील की जो indigenous population थी, that was reduced to less than 2 lakhs. North America में 1492 में the population was 1 crore 40 lakhs. 1 crore 40 लाख पॉपुलेशन थी नॉर्थ अमेरिका में इंडिजिनियस पीपल की, जो कि सिर्फ 4 लाख पे बची है इस समय। इन नॉर्थ अमेरिका हंटिंग इंडियंस विद डॉग्स, अब ये आप सुनिएगा उन लोगों के क्या शौक हुआ करते थे। इन नॉर्थ अमेरिका हंटिंग इंडियंस विद डॉग्स वाज नोन एज स्पेनियार्ड्स मेथड. इट वाज एडवांस्ड बाय कॉटन माथर एंड अनदर क्लर्जीमैन. रेवरेंड सोलोमन स्टोडार्ट, an eminent religious figure of England, he proposed to the Massachusetts governor that colonists must be given financial wherewithals to purchase and train large packs of dogs. Why? To hunt Indians as they do bears. This is, मैं ये जो सारी आपको बातें बता रहा हूँ, उस टाइम पे ये लोग अपने आप को सिविलाइज समझते थे, जैसे आज हम डिस्कस कर रहे हैं इंडिजिनियस पीपल को, we think we are more civilized people, we are more civilized than other people. So at that time they were thinking कि भी they were more civilized. अब आपको उससे थोड़ा सा और नीचे लेकर के आता हूँ 1823 में. 1823 में जो है सुप्रीम कोर्ट ऑफ यूएस जस्टिफाइड द डॉक्ट्रिन ऑफ डिस्कवरी. मैं आपको शुरुआत में डॉक्ट्रिन ऑफ डिस्कवरी बताना भूल गया. इन 1494 जब आप पोप अलेक्जेंडर ने इनको स्पेनियर्ड्स को अफ्रीका कैप्चर करने के लिए पूरी छूट दे दी थी, उसके बाद में इनमें स्पेनियर्ड्स में और जो है पोर्चुगीज में लड़ाई होने लगी, तो इन दोनों में एक ट्रीटी हुई कि भी ये जो है ट्रीटी, दैट वाज डॉक्ट्रिन ऑफ डिस्कवरी. जो ढूंढ लेगा जमीन को वो जमीन उसकी हो जाएगी, प्रोवाइडेड इट शुड नॉट बी ए क्रिश्चियन लैंड. ओनली क्रिश्चियन पीपल वर ऑथराइज्ड to discover and own the title to those lands. ठीक है, 1823 में यूएस की, अब हम लोग अपने आप को समझदार समझते हैं, and it became an independent country somewhere in 1761. यूएस became independent. 1823 में यूएस की जो है सुप्रीम कोर्ट ने इस डॉक्ट्रिन को सही ठहराया कि भी हाँ, क्रिश्चियन जो लोग हैं उन लोगों को ये टाइटल्स हैं, बाकी देवर द इंडिजिनियस पीपल वर डिप्राइव्ड ऑफ द टाइटल ऑफ द लैंड, देयर कल्चर, देयर लैंग्वेज, एवरीथिंग. अब ये मैंने आपको बताई 1820.
You have a minute to go, sir. You have 1 minute more, sir.
हाँ बोलिए.
Wind up.
हाँ बोलिए. अच्छा, I should wind up. नहीं भाई, 2-3 मिनट और.
आपके पास 1 मिनट है और you can wind up. You can conclude.
नहीं मैम, please. I can't wind up within 1 minute. You'll have to just give me 2-3 minutes. Give me 2-3 minutes. मैम 20th century में अगर अभी आ जाते हैं हम लोग यहाँ पे, जैसे when I filed this abstract of this paper, after that one news broke up. 1000 graves of indigenous people were discovered in Canada. आप लोगों ने सबने न्यूज आइटम पढ़ा होगा. क्या है कि कनाडा में एक इंडिजिनियस पीपल्स के लिए जो है स्कूल बनाए गए, है ना. वहां पे जो है उनको करेक्ट करने के लिए कहा गया कि ये इस प्रॉब्लम को सॉल्व करने के लिए, इस तरीके से इंडियन प्रॉब्लम को सॉल्व करने के लिए हम लोगों के पास इससे बढ़िया ज्यादा कोई मेथड नहीं है कि इनकी जो है कल्चर, इनकी लैंग्वेज, अगर आप मेरे पेपर में वो ऑल द डिटेल्स आर देयर, if we take away all these things, so these people will become more civilized. Same with the Akansu tribe of Brazil, only 4 persons are left. Jarawa in Andaman Nicobar, 400 left. Rendalis in Baltic, only 200 are left. Nukak in Colombia, 420 are left. Soach in Cambodia, 110 are left. Great Andamanese tribe, now I am telling you 3 or 4 tribes of India, 44 are left. Onge 101. Khamar 606, ये बिहार के ही एक ट्राइब है. So what happened is कि जिस तरीके से इन्वेड करा गया, it is not only the environment change, the contagious diseases covered all these people, है ना. The genocides were more responsible for the annihilation of these tribes. Now, before we further move, I would quote another words from Jomo Kenyatta, who was the first Prime Minister and President of Kenya. He said, when missionaries arrived, the Africans had the land and missionaries had the Bible. They taught us how to pray with our eyes closed. When we opened them, they had the land and we had the Bible. Same thing is continuing in India as well. Maybe indigenous people are not losing their lands, but they are very much losing their culture, their language, their traditions. आप नॉर्थ ईस्ट स्टेट्स में जाकर के देख लीजिए, या झारखंड, बिहार वगैरह में, मध्य प्रदेश में जाकर के देख लीजिए.
Thank you
very much, sir.
You are now. Yes.
Extra time is also up, sir. I'm sorry.
We're extremely sorry, sir, but we need not violate the rights of other presenters. If the chair allows us, could we start with the next presenter? Yes, Ms.
Please keep
Prajakta.
time. Vijay Lakshmi, request you also to keep time so that I'm not in the wrong on this.
Sure, ma'am. And my sincere request with folded hands, all presenters, we understand that it's all your hard work that you've put, but we cannot be unfair to the others. So I kindly request all of you to adhere to the timelines given to you, 15 minutes. Ms. Prajakta, please kindly continue.
Yes, ma'am. Thank you. I would like to inform the chair that Ms. Priya Singh, she has requested that she will be joining a little later as she is in her examination. And Ms. Nosha Rani has informed that due to some technical reason, she is unable to join it. So with the permission of the chair, I would request Mr. Lino Jose and Dil Krishna to present their paper. Mr. Lino Jose. Both of them are from both of them are from Al Azhar Law College, second semester 5-year BCom LLB students, and the topic what they are going to present is mental health of women. Over to you, Mr. Lino and Mr. Dil Krishna.
I'm audible.
Yes, you are audible.
Good afternoon to all the panelists and attendees presented here. Myself, Sri Krishna PS, and my co-author Lena Jose is here to present our research paper on mental health of women. The COVID-19 pandemic has affected women more than men, both as frontline workers and at home. The aim of our article was to analyze the differences observed in mental health and violence between men and women in the COVID outbreak. This devastating pandemic has affected nearly every aspect of daily life. While nations struggle to manage the initial waves of the death and disruptions associated with the pandemic, second wave is building rising rates of mental health. The imminent mental health surge will bring further challenges for individuals, families, and communities, including increased death from suicide and drug overdose. Women and girls face disproportionate impacts with far-reaching consequences that are only further amplified in contexts of fragility and conflict and emergency. There were several risks on specific situations of pregnancy during the pandemic. Infectious risk. Several papers have reported a high rate of maternal and neonatal complications in COVID-19 positive pregnant women. All the uncertainties are likely to increase the level of psychological stress and may contribute to increased risk of pregnancy termination. Psychological risk. The pandemic can be particularly distressing during specific situations such as pregnancy. In the COVID-19 cohort, women with previous psychiatric diagnosis or low income were at higher risk at reported elevated distress and psychiatric symptoms. The psychological adjustments of normal pregnancy are complex, and those of high-risk pregnancy are even more pronounced and severe. Potential risk for children. Moreover, we do not know yet the after effects of maternal exposure to COVID-19 infection and the risk of future mental disorders in offspring, since the virus may have toxic effect on fetal brain. The first case of neonatal with the white matter injury due to COVID-19 infection. At 2 months after birth, the neonatal hypertonia was improved and white matter lesions were reduced. However, early brain lesions may increase the risk of further mental disorders. The next is postpartum depression. Those who develop postpartum depression are at greater risk of developing major depression later on in life. Your body and mind go through many changes during and after pregnancy. If you feel empty, emotionless, or sad, or most of the time for longer than 2 weeks during or after pregnancy, reach out for help. If you feel like you don't love or care for your baby, you might have postpartum depression. Women with PTSD are thought to be higher risk of parental loss, pregnancy complications, ectopia pregnancy, and growth abnormalities in the future. Women who have had clinical depression before miscarrying are more likely to develop PTSD. Post-traumatic stress disorder is associated with miscarrying along with other traumatic events associated with the pregnancy. Ma'am, now I would like to welcome my co-author Lena Jose for the rest of the presentation.
Ma'am, am I audible?
Yes.
Yes.
Yes, ma'am. Let me continue our topic. Miscarrying and mental illness. Mental illness can be consequence of miscarrying or early pregnancy loss. Even women can develop long-term psychiatric symptoms after a miscarriage. Acknowledge that potential of mental illness is not usually considered. A mental illness can develop in women who have experienced one or more miscarrying after the event or even years later. Another point, psychiatric symptoms in COVID-19 positive patients. The reported COVID-19 positive patients had higher level of depression, anxieties, and post-traumatic stress symptoms as compared with the normal controls. Women reported significantly more perceived helplessness as compared to men and controls. Another point on domestic violence. Intimate partner violence includes physical or sexual violence, emotional abuse, and stalking. It is the major cause of homicide death for women. Victims of intimate partner violence are at increased risk for multiple mental disorders as well as stomach diseases. Exposure of children to family violence may also increase the risk of violence in their old relationship. Several risk factors have been identified: low income and social isolation, loss of loved ones, etc. All these risk factors usually associated with the intra-family violence are increased during epidemics. In addition, male argumentation with or without alcohol often appears as mode of reaction to a crisis. Let me conclude that social support is key protective factor. Similarly, treating may be sustainably more success during a pandemic. Gender disparities may be accelerated, particularly for employed women or single parents, as women are disparately responsible for the bulk of the domestic tasks, including children care and elder care. Violence against women necessitates a fundamental long-term struggle and practical intervention strategies. These changes must come from within societies themselves and not be of the order to effectively change mentalities. This starts with the education within the family core and requires collaboration between civil society and government to promote real long-lasting changes. Thank you.
Mr. Jose, if you're speaking, we cannot hear you because you put yourself on mute.
I concluded. Thank you, ma'am.
Okay. Thank you, Lino, Jose and Dil Krishna. I would now request the next presenter, Mr. Vallan, student of Tamil Nadu National Law University, to present the paper titled Whether the Indian Policy Complied with International Standards While Enforcing COVID-19 Lockdown. Over to you, Mr. Vallan.
Am I audible, ma'am?
Yes, you are.
Am I visible too?
No.
Now, ma'am?
No.
Just a minute. Okay, no issues, ma'am. I'll just continue, ma'am. Is it possible for me to share my PPT?
Yes.
Yes. Hope it is visible. Is my PPT visible, ma'am?
Yes.
Okay. Thank you so much. respected chairperson of the session, dignitaries, faculty members, and my co-presenters, and last but not the least, the convener of the session. A very good afternoon to everyone. And this is Valin, and I'm a student of Tamil Nadu National Law University. And I'll be presenting my research paper entitled Whether the Indian Policing Comply with International Standards while enforcing the COVID-19 lockdown. As the name suggests, you all would have noticed what subject matter that I'll be dealing in today's presentation. I'll start with few clippings. Hope everybody will be familiarized with all these clippings. We know that the pandemic lockdown has increased the visibility of the police brutality in India. On the eve of the first anniversary of the hangdog Sathankulam custodial death, during the first phase of lockdown, there was yet another death due to the police attack inflicted on a farmer in Salem district of Tamil Nadu. In front of us, we see doctors were slapped, patient service auto drivers were canned, citizens were punished with sit-ups, squats, murga punishments, and arbitrary lathi charges have resulted in slaying of innocent citizens. And perhaps these are just tips of the iceberg of police high-handedness during the enforcement of COVID-19 lockdowns. It is quite astonishing for me to note that generally, 3 out of 4 police personnel in India feels that it is justified for them to be violent towards criminals. This infers and make us conceive that though police brutality is not spanking new to India, this COVID-19 pandemic has increased its visibility and degree of cruelty manifold. And this will be the central point of analysis that I've carried out throughout my research paper. And further, I would like to give a quick overview about the police brutality in a global perspective. The enforcement of COVID-19 lockdown and restrictions have increased the police brutality in worldwide across the globe, and tortures and ill treatments were commonly evidenced in streets of Moscow and Minneapolis during the enforcement of curfews in their country borders. Similarly, Pakistan police have enforced the lockdowns with inhumane corporeal punishments. And allegedly, Kenyan policemen have killed 15 Kenyans. Yes, 15 Kenyans, owing to the dusk to dawn curfew imposed by the government. Further, there are lots and lots of incidents have reported across the European countries such as Belgium, France, Greece, Italy, Romania, and Spain, where the law enforcement officials used unlawful, disproportionate, and arbitrary force to enforce lockdown protocols despite the lack of resistance and threats from the people. More pathetically, El Salvador policemen had also canned and shot a young man twice in his leg who went out for buying food and fuel during the national quarantine. Down the line, India is not an exception, as we have seen a lot of clippings in the previous slide, and where a 32-year-old man who stepped out of his home during the lockdown to buy milk was allegedly beaten to death by the West Bengal police. And furthermore, Uttar Pradesh witnessed humiliating acts of police who forced the migrant workers to hops on the streets, and in specific, 12 citizens have died due to the police exercise within 5 weeks of national lockdowns, that is March 25th to April 30th. And I'll be starting my presentation, my in-depth presentation, with these 3 questions before you. Does Indian municipal laws reflect the ethos of international law? Number 2, if not, can India be held bound by the international laws in the municipal sphere? If yes, where does India lack in meeting the objectives of international laws against police brutality? I'll get you through the international commitments that India ought to fulfill. That is the Universal Declaration of Human Rights through Article 5, and the International Covenant of Civil and Political Rights through Article 7. Though this UDHR and International Convention of Civil and Political Rights prohibits torture, cruel and degrading treatment or punishment, The third one, that is the Code of Law Enforcement Officials of 1979, insists that it serves to be a very crucial document that sets and emphasizes standards for the enforcement officials. In specific, Article 2, and I'm quoting, says, in the performance of their duty, the law enforcement officials shall respect and protect the human dignity and maintain and uphold human rights of all the persons. And Article 3 also says, law enforcement officials may use force only when the necessary and to the extent it required for the performance of their duty. Now you might ask me a question. Oh, well, and stop. The word necessary and reasonable has been used in all the international documents. Having said that, could strict enforcement of COVID pandemic lockdown justify the use of force by police in India? That will be a very significant and very reasonable question, and the answer could be derived from the same document, that is Article 5 of the Code of Law Enforcement Officials, which explains that national security or any other public emergency in the instance case, that is the COVID-19 pandemic, cannot be a justifiable ground for the police to inflict, instigate, or tolerate any act of torture, other cruel, inhumane, or degrading treatment or punishments. So what did India did as a signatory of the Code of Law Enforcement Official is the next question. India, being a signatory of that code, has come up with the Code of Conduct of Police of India in 1985, which also emphasizes that in securing and observations of law and maintaining order, the police should, as far as practicable, use the methods of persuasion, advice, and warning. And when the application of force becomes inevitable, only irreducible minimum force required in that circumstances should be used. So I have made you travel through what are all the international commitments that India had, and now we are going to check whether such international commitments are binding in India. And towards checking the binding, I essentially highlighted two perspectives in my paper, namely the monist and dualist perspectives. As the name suggests, everybody might be familiar about it, but I'll make it very short, that from a monist perspective, the national and international law forms one single legal order or number of interlocking order, which is presumably coherent and consistent. On the other hand, in a dualist perspective, and propagandas of dualist theories advocates that in the international law and the national legal system holds distinct and independent character. However, I have argued in my paper that the assertion of any one of these theories or perspectives to be ideal and compartmentalizing states into monist and dualist group would be inappropriate, because I have identified that the origin of applicability of international law at municipal sphere is derived from the constitution of a country that of course varies from across nations. For instance, in India, we know that Article 51C, that is the Directive Principles of State Policy, which states that states shall endeavor to foster and respect for the international laws and treaty obligations in dealing with the organized peoples with one another, which also goes in line with Article 26 of Vienna Convention, which read that every treaty in force is binding upon the parties to it and must be performed by them in quote-unquote good faith. Having said that, I've also analyzed and identified a judicial trend from the Gramophone Company of India versus Barindra Bahadur Pandey case and the famous ADM Jabalpur case versus Shukla are few of them, which asserts that the Indian municipal law places the municipal laws on a higher pedestal without necessarily implicating the theory of transformation. In the context of prevention of police brutality, arguing on bindingness of international law in the Indian municipal sphere becomes irrelevant. Yes, I'm saying it is irrelevant as there is no denial and confrontation of any international anti-police brutality standards and its bindingness. Therefore, here I am making a significant deviation. That is, the critical analysis of the Indian domestic sphere assumes greater importance to identify where does India lack in meeting the objectives of the international law against police brutality. And my subsequent part of the paper has been directed in that direction. Now I'm going to the 3 questions. The first question. Yes.
Sir, please kindly wind up as early as possible because you're exceeding your time limit. You're
Sure.
requested to give a small conclusion so we can move ahead.
Okay, ma'am. Okay, sure. So I'm, as I've told, I've started this 3rd question, and I went on to analyze the Indian domestic sphere. And what made me to find out that one of the significant contributed factor for the police brutality during the lockdown is this delegated legislation. So I'm not going to in depth due to paucity of time as to what the delegated legislation means, or how the police got the power through the delegated legislation that I've clearly mentioned in my research paper, and going to the other sense. In a very simplistic manner, I'm telling that the delegated legislation has given enormous power to the executives, and thereby the police got a lot of powers to enforce the lockdown strictly. And here comes the question whether that power, discretion power, is a discriminatory power. And the Indian judicial trend says it's not a discriminatory power as long as it has the standards and norms for enforcement. Of course, the delegated legislation, that is the orders by the government, have the standards and norms of delegation in terms of the penal provisions attached in its appendix. So I have checked the ultra virus. So the result is both the delegated legislations are both substantively and procedurally intra-virus. And also you might ask me a question, if it is substantively and procedurally intra-virus, what's wrong in that? Is that a pure problem at implementation level? I've also analyzed that by using the Professor Jeffrey Jovel's test of proportionality, and it has not been satisfied. And so what is the reason that made the problem at implementation level is the lack of clear procedure for enforcing lockdowns, that is ambiguous provisions in the delegated legislation. That is paragraph 15 states there should be strict enforcement, but how that strict enforcement should be carried out has not been mentioned, where the procedural norms had been implicitly stated in the annexure rather than stating it in the guidelines itself. That's one of the significant problems that I've identified. And we know how the delegated legislations, parliamentary control has played a role in the pandemic, which was very ineffective because they couldn't sit for the deliberation. And also the judicial control has also been failed because all the high courts had made the significant efforts to cordon the police brutality only after a couple of months, where the police brutality has started the very next day of the imposition of lockdown. And also more specifically, the High Court of Bombay specifies that police are justified to use the force where people are not obeying for the orders. And also role of NHRC and HSRC was also not so effective, though that has taken effective methods only after this 2 months. And by that, I'm making following recommendations. That first, I have seen how the international mandates have affected domestic law, and how the domestic law has its consonance with international law, and how the domestic law values the delegated legislation, which is both substantively and procedurally intra-virus. So what is the problem is at the ineffective implementation of the delegated legislation. Of course, it's not just an implementation level error, but also at policy level with ambiguous provisions. So number one, the ambiguous provisions in delegated legislation should be made more explicit. And number two, to make the police accountable, it should, all Indian states should establish police complaint authority. And number three, sensitizing police-oriented form of service-oriented form of policing. And number four, there should be a proactive role of judiciary and NHRC and State Human Rights Commission in actively upholding the human rights. And last but not the least, the supportive work culture should be showed by the citizens through the reasonable adherence to the lockdown protocols, because it's completely futile to just blame the police and executives and government authorities, as it has been also observed
Thank you, Valen, for your presentation. I'd request the chair. Can we proceed further, ma'am?
Yes.
Thank you. The next speaker, Ms. Prajakta.
The next speaker is Ms. Manju Priya and Ms. Kusumika Sen, students of Tamil Nadu National Law University. And they are going to present a paper on the effect of governmental intervention with respect to COVID-19 on refugees and asylum seekers, a comparative study of US, Belgium, Greece, and India. Over to you, Ms. Manju Priya and Ms. Kusumika.
Am I audible, ma'am?
Yes, you are.
Thank you. A very good afternoon to everybody present here. I would like to share my PowerPoint presentation before I start with the presentation. Is the screen visible? Is the PPT visible, ma'am?
Yes, it is. Yes, it is. I'd request before you start, please kindly adhere to the timings, dear. Yes?
Sure.
Yeah, thank you.
So, the COVID-19 pandemic has laid naked the pre-existing social inequality in a society. Therefore, the populations which were already vulnerable had suffered disproportionate effects than the rest of the population. This vulnerable population includes many, including minors, women, children, other sexual minorities, and refugees and asylum seekers. So in this paper, we have done a comparative study of US, Belgium, Greece, and India to see the effect of governmental intervention with respect to COVID-19 on these populations. Now, through this paper, we argue that the governmental policies are discriminatory and systematically excluded the refugees from the welfare schemes. So the scheme of my presentation will be, at first, I will talk about the rights of the refugees and the asylum seekers that has been enshrined in the international human rights instruments. And then I would deal with the jurisdictions, Greece, Belgium, and US. And lastly, the Indian jurisdiction will be dealt by my co-presenter, Manju Priya. So this is the scheme of my presentation. Coming to who is a refugee. So according to the 1951 Convention relating to the status of the refugees, a refugee is a person who has forcefully been displaced across the national borders and is unable or is unwilling to return to their home country due to fear of persecution due to race, religion, nationality, or membership of a political opinion or a social group. Now here it is to be noted that there is a distinction between asylum seeker and a refugee. An asylum seeker is a person who is whose status is an asylum seeker before they are granted the status of a refugee by the contracting state or the UNHCR. Now coming to the rights that are being granted by all the international human rights instruments. So humanitarian imperatives underpin the relationship between refugee law and human rights. Asylum seekers and refugees are entitled to all the rights and freedoms outlined in the international human rights instruments. Now these rights include right against arbitrary arrest, detention, or exile, which is enshrined in Article 9 of UDHR, right to seek and enjoy in other countries asylum from persecution, right to nationality, right to freedom of movement and residence within the borders of each state, right against cruel, inhuman, or degrading treatment, right against being discriminated on grounds of race or religion. Now, all these rights have been guaranteed in UDHR, some in ICCPR, some in ICESR, some in CEDAW. They also have a right not to be forcibly returned or expelled to a situation that would endanger one's life or a freedom to freedom, and this is a key component of international protection. This is the principle of non-refoulement, and this principle has been enshrined in Article 33 of the 1951 Convention. Now, having walked through all the rights, I'll take you to the overview of the refugee population. Now, according to the UNHCR report, there are 4.1 million asylum seekers and 26.4 million refugees by the end of 2020, and total 82.4 million of forcibly displaced people worldwide. So we can imagine the population and we can understand the gravity of the situation. So coming to the first jurisdiction that we have compared, the first is Greece that we have compared with. So Greece is basically a home to a number of refugees and asylum seekers, especially from those from Asia, Africa, and Middle East. In Greece, there is a reception center called the Moria Reception Center, Moria Reception and Identification Center, and it is the largest and the most congested refugee camp in the Europe. So naturally, there were apprehensions, yes, because it was the most congested. There were apprehensions that such an outbreak like COVID would ravage the asylum seekers in the islands, who were already vulnerable owing to their inhuman living conditions. However, we saw that such predictions did not materialize later, and there were no COVID cases during the first wave of COVID, and there were no reported cases of any COVID in those camps. However, in spite of 0 COVID cases being reported in those camps, as a precautionary measure, we saw that the Greek government authorities had started to decongest the refugee camps under the relocation scheme. This relocation scheme was launched by the European Commission for relocating the unaccompanied Greek minors to 11 European Union members. Now, this relocation scheme had fetched a lot of protest from such community, for such refugee community, mainly because they were again sent back to their countries, to those European Union countries in which they feared persecution. So therefore, it fetched a lot of protest. But however, those people, those refugees and asylum seekers who had stayed back in the camps had to remain in the deplorable camps. The authorities repeatedly extended the lockdown in the camps, even though there was no reported case of virus in the camps. And the lockdowns were announced, the lockdowns were basically announced only in the refugee camps. And so they were not announced in the rest of the country, but only in the refugee camps. This discriminated between the others, that is the rest of the population, and the refugees who were living in those camps. So this basically, when they were restricted and only lockdowns were announced in those camps, this restrained the refugees' freedom of movement to access to a safer place and a hygienic place, and access to other healthcare and socio-economic benefits. Later, in March 2020, the government closed doors to asylum seekers from Turkey after the Turkish president opened its doors, allowing the refugees to enter Europe. Now, the United Nations had already accused the Greek authorities of using the first wave of COVID as an excuse for detaining them or restricting their entry into the country. UNHCR also took similar position. However, therefore, we can say that they cannot suspend the internationally recognized right to seek refuge and the principle of non-refoulement, both of which have been highlighted by all the international human rights instruments. They also have the International Protection Act, which came into force on 1st January 2020, which broadened the grounds for denial of protection and which legitimized imprisonment even for unaccompanied minors. Now, it limited asylum seekers' recourse to legal counsel and modified the appeals mechanism to make it more difficult to have the initial rejections overturned. But finally, in November 2020, the Greek authorities published a statement that it will not keep the unaccompanied minors in police custody. Later, this was the case in first wave of COVID. During the second wave of COVID, however, there were reported cases of coronavirus in those camps, especially the Moria camps. So, therefore, this intensified the lockdown procedures in the camps. And finally, on September 8, 2020, a fire broke out in the camps and destroyed that largest camp, Moria refugee camp. However, though there was no proof that the refugees had actually initiated the fire, the Greek migration minister started blaming the refugees and the asylum seekers for that fire. So therefore, because of the fire, the Moria refugee camp was destroyed and a temporary refugee camp had to be built up. And before the temporary refugee camp could be built up, thousands of refugees actually were left on the streets, and thousands tested positive. And finally, when the new refugee camp was built up, a temporary shelter, that was worse, which lacked access to safe water, food, toilets, electricity, menstrual products, healthcare, and psychosocial and legal support.
Ms. Sen, I'd request you to kindly wind up your presentation.
Yeah.
Please
Sure.
give the recommendations, suggestions.
Sure, ma'am. So next, so we can see how the Greek authorities had discriminated against the refugees, against the rest of the populations. The next we come to Belgian response. The Belgian response was also very similar to Greek response if we look into it. I have actually mentioned it in detail in the paper. They had suspended their officers that accepted the asylum claims to the public. A month later, again, they had initiated it online, but again, it was accessible only in Dutch and French. That's why it was sort of not accessible to the refugees properly. Similar was the situation, deplorable situation of detention centers in Belgium. And the third is the United States. In the United States, they had actually, the problem was during the first wave of COVID, their migration protection protocol had made the US to push back the asylum seekers to Mexico, while the Mexican government had actually opened the borders for the asylums to move. So going by all the three countries, we see how the three countries have discriminated against the refugees. Now the Indian perspective will be dealt by Manju Priya. I would request Manju Priya to deal with it. Thank you.
Hello, ma'am.
Ms. Manju Priya, please kindly be crisp. You have only 2 minutes to conclude.
Yes, ma'am. Yes, ma'am. So when we see the governmental intervention and COVID-19 from the Indian perspective, we first see the status of how the refugees are being regulated in India. Since we don't have a domestic legislation for refugees, as well as we have not conceded to the Convention on Status of Refugees 1951, as well as the 1967 protocol, we don't have any laws which governs refugees. So currently, how it is being done is through customary international law, which is incorporated through domestic laws, provided it is consistent with the already existing municipal laws and constitutional guarantees of in specific Article 51 Clause C. So this is how currently the refugees in India are being regulated. So when we look at how Indian governmental intervention has been to the refugees in light of COVID-19, we could see that it is consistently based on two, which is the right to health, as well as the right to nationality and documentation. Since we don't have a law in place, there has been no regular clarity of how the refugees are being governed in India. And also we don't have any documentation to even let them avail the schemes which the government imposed during the lockdown. So this was the major concern, underlying concern, which caused a lot of effect on the worst effect on the refugees in the COVID-19 pandemic. So I'm just going to kindly keep it brief here. This also led to how the Aadhaar schemes was held as a precondition to avail many benefits such as vaccination or healthcare facilities or even drugs, life-saving drugs. So all this was not able to be availed by the refugee groups as well. So keeping in this, I conclude that when we look at all the four jurisdictions, the governmental intervention has been discriminatory towards the refugees. This is the case in spite of there being a number of human rights instruments. So we could say that the refugees' rights were merely paper-based and not in practical reality, it was not enforced. However, we could see that the Belgium had a better understanding of how the refugees function, and they were able to govern them better merely because of the fact that they had a refugee laws in place and they were able to identify these refugees. Thank you, ma'am. That's all.
Oh, we have one last presentation. Yes, Rajat.
Yes. I would now request Ms. Priya Singh, student of Chanakya National Law University, to present her paper titled Protecting the Human Rights of People Living with HIV/AIDS. Over to you, Ms. Priya.
Good afternoon, everyone. I am Priya Singh from Chanakya National Law University. My theme of the paper is Protecting the Human Rights of People Living with HIV/AIDS. In the last few minutes, I am going to deal with the brief introduction of HIV/AIDS, causes, treatment, and prevention. In the second part, I will be dealing with the concept of human rights in relation to HIV patients. In the third part, I will be dealing with the main issues of discrimination, consent, and confidentiality of infected patients. And in the last part, I will be dealing with the ideas to combat HIV/AIDS. So, the acquired immune deficiency syndrome is one of the deadly diseases which came in the world in the year 1981. This virus is deadly and dangerous because it completely destroyed the immune system of the body and subsists in the body without showing any symptoms. The virus is very small and not even observable by the microscope. Since the epidemic began, on an average 60 million people have been infected with the disease and estimated 30 million people have died from AIDS-related cases. AIDS has become one of the sixth largest and deadliest cause of death worldwide. Most of the researchers believe that HIV originated in sub-Saharan African country in the 20th century, and now it is pandemic with more than 38.6 million people are infected with the disease. 20 years after the first case of AIDS was reported, it has become one of the most dangerous diseases of humankind. More than half of a new kind of infection hit people aged below 25 years. Girls are more prone to this disease than boys, and more than 14 million children are orphaned because HIV/AIDS. This disease reverses development in some countries, especially our younger generation. In the next part, I have dealt with the concept of human rights in relation to HIV/AIDS. As we know that humanity is greatest and above all religion, and human right is one of the most sacred one, which is natural and fundamental. Human rights are inherent and derived from the dignity of a person, and people living with this disease are subject to discrimination in our society, in workplace or in the government services. Women whose husbands are died of AIDS are rejected by their own family members and in laws, and they are also deprived of their property. Thousands of children have lost their families, and those whose parents are living with the disease have lost their inheritance right. Sometimes AIDS patients have to take hazardous, including the prostitution, and they have been forced to live on the street and suffer lots of abuse. Sometimes the situation even become more complicated as these old issues give birth to a new problem, like access to employment of people suffering from AIDS has continued to occur. Patients of HIV are now run to the risk of exclusion from the workplace health scheme with a large impact on health and their capacity to work. In the next part, I have dealt with the relationship of HIV/AIDS and the human right, which is highlighted by mainly three factors. First is increased vulnerability. Certain communities are more vulnerable to HIV/AIDS because they do not know their civil, cultural, or economic rights. Women, especially the younger women, are more prone to infection if they lack access to education, information, and necessary service to ensure about reproductive and sexual health and to prevent their infection. In the second point is discrimination and stigma attached to it. The infected person is often subject to human rights violation because of their societal status of HIV, causing them to suffer both the burden of disease and the loss of human rights. And the third point is impetus and effective response, which gives us the way to address the infection. Infections are hampered when human rights are not respected. In the fourth part, I have dealt in the paper with the legal position in India. As we know that HIV/AIDS is not recognized disease in India. In India, we do not have the legal development in the area of confidentiality about the disease. The Supreme Court in certain cases has recognized the right of privacy and also uphold the duty of the physician to keep patient confidentiality. Further, it held that Code of Medical Ethics formulated by the Medical Council of India creates an exception to confidentiality when health of public is at stake or where there is a future of public is at risk. The court also said that the positive status to spouse was not breach of principle of confidentiality since the wife was saved by such disclosure. The court also affirmed that the positive person who marries and spread the disease to the spouse will criminally liable under section 269 and 270 of the Indian Penal Code, which criminalize those persons who negligently or malafidely spread the disease and which also endangers the human life. The Medical Council of India 2002 regulate the conduct of medical practice of the medical practitioner in India. It outlines the duty of doctor in maintaining the confidentiality and situation that a doctor shall not disclose the personal information of patient except if it is required by the court in the notifiable disease or when there is a serious risk to a particular person or group. In the last part, I have dealt with the ideas to combat HIV/AIDS. As we know that HIV/AIDS is not just a medical problem. The ways in which the virus is affecting our society gives us intricate ways in which social, cultural, and political factors causes certain section of society more vulnerable. The epidemic reveals the ways and impact the discrimination and inequality in clearly terms. Marginalized people in our society have very little knowledge and access to the fundamental rights and basic rights such as food, basic medical facilities and information. Many of the communities are criticized by society at large and their lifestyle is criminalized, making them more problematic to participate in the mainstream process where they can demand their basic rights. This is very minimal awareness about the disease and no alternative for the safer lifestyle. The harsh reality of this disease is that people is becoming HIV positive because they do not know their right or do not have access to their basic fundamental right. So we need to find the ways and strategy to successfully fight the enemy named AIDS. The most important work is to prevent the spread of disease and take care of those who are infected with HIV. And the only ways through which we can win this battle over AIDS is from social and personal effect. The most important effect is to be made by the person living with HIV and the person around us, is that we are battling for them and for their rights. If infected person is not strong enough to fight with the disease and the wrong done against them in the form of discrimination and infringement of their rights, we cannot go ahead alone. Positive status does not take human rights. We cannot go ahead along without them. So the misconception related to it is very bad. So in our first requirement is to spread awareness about the disease and misconception associated with it. Awareness needs to be spread in two ways. Firstly, by making people aware of their right, and second, to prevent its spread. This information needs to be given especially to the marginalized population like homosexual, women, children, sex workers, and various other institutions like hospital and private sector. There is also a requirement for the change in the behavior of people towards HIV, and this can be enforced if proper information is severed effectively to the people on HIV. Legal effort should always also be taken beside the personal and social effort. So I want to conclude my presentation with a small note that world is not a small place and the people living with HIV cannot survive with all. After researching on this topic, I have come to the conclusion that we all are surrounded by the most deadly problem in the name of AIDS, and AIDS is one of the dangerous enemies and it is becoming stronger day by day. We do not know about this and we always prone to this disease. So those who do not know who do not know, we need to aware them. We need to educate them. It is a disease which cannot be cured, but only be prevented from its spread. So in order to prevent the spread of this virus, we need to make people aware of this deadly disease, and treating people humanly is very much important. And law will definitely help in this regard. That's all.
Thank you, Priya. If the chair permits, could we have a few questions, madam? If any of the panelists, madam, you are on mute. Mute. Yes.
Yeah, we would open the discussion to questions if there are any.
Yes.
Yeah, but yeah, I think Ranjana has something. Yes, Ranjana.
Please, ma'am.
My first question is to Dr. Vivek Mishra. Is he here?
Yes.
Yeah, very much.
Okay, sir. Sir, first of all, like it was a wonderful topic. The only thing there was paucity of time. Time की कमी थी, इसलिए आपने ज़्यादा cover नहीं किया. But you started very nicely, and gave the historical. But I have a small question, and the question is, what are the challenges for indigenous people?
Just please repeat your question.
What are the challenges of indigenous people in India?
Well, I would have discussed, had I got some time, I would have certainly discussed this issue because.
Mishra, can I add a question which will go along with that when you answer? Since our topic of the webinar is the second wave of COVID-19, so you can associate the answer that you're giving Professor Ranjana's question with the second wave of COVID-19. So what are the challenges faced by the indigenous people in India in this second wave of the pandemic? That would make it really, really important for this webinar. Thank you so much.
Well, I would associate it with the second wave of COVID as well. But the challenges faced in India are two prongs, ma'am. Or rather say everywhere the same challenges are faced. I discuss it from the international perspective because the more we are going towards industry, or rather say, as we said, I said, the more we think we are more civilized, we should upgrade their lifestyles. What do we actually want to do with them? That concept should be clear in our mind first of all. हमें उनके साथ करना क्या है, हमें उनको उनके हालात पे छोड़ना है, उनके कल्चर को वैसे ही प्रिजर्व करना है, मेंटेन करना है, उनकी लैंग्वेज को प्रिजर्व करना है,
ourselves. Second thing, in the context to this COVID, of course, they suffered. They suffered because the kind of facilities which were available to the urban masses were not available to these indigenous people. And as I started with, in India or everywhere, at what cost do we want to improve their status? Either we can go for industrialization. अभी मैंने आपको ब्राजील का, इसी में मेरे को मौका मिल गया था, मैंने आपको एग्जांपल दिया था, ब्राजील में कौनस्का ट्राइब है जहाँ के 4 लोग बचे हैं सिर्फ. क्या हुआ, 1990 में गवर्नमेंट ने बैन लगा दिया कि उनके एरिया में कोई नहीं जाएगा, उनके एरिया में कोई जो है वुड कटिंग नहीं करेगा, किसी तरीके का इंडस्ट्रियलाइजेशन नहीं होगा, कुछ नहीं होगा. What happened is the poachers, the loggers, they circumvented this government directive. जाकर के उन्होंने सारे उस ट्राइब्स को ही खत्म कर दिया. जो थोड़े बहुत अपनी जान बचा करके जंगल में भाग पाए, अब वो ट्राइब ही खत्म हो गए, तो फिर गवर्नमेंट के डायरेक्टिव का कोई यूज ही नहीं रह गया. समथिंग लाइक आई गिव यू एग्जांपल ऑफ 2 एग्जांपल्स, वन सरदार सरोवर डैम एंड द अदर ऑफ वेदांता इंडस्ट्रीज इन नियमगिरी. आप लोगों ने बड़ा सुना होगा, नियमगिरी में वेदांता इंडस्ट्री आई थी और उसका बहुत प्रोटेस्ट हुआ. यू सी देयर आर 2 एंगल्स. एक तो जो वहां के इंडिजिनियस पीपल थे उन लोगों ने भी प्रोटेस्ट करा, एंड सेकंड थिंग, चीज को जो है पॉलिटाइज कर दी, उसमें जो है पॉलिटिक्स डाल दी गई थी. पर्सन हैज बीन नेम्ड, ऑफ कोर्स आई हैव नॉट नेम्ड दैट पर्सन इन माय रिसर्च पेपर, फ्रॉम सीपीएम. दे वर प्रोवोकिंग पीपल कि भी ये जो है डेवलपमेंट यहाँ नहीं होनी चाहिए. उसी तरीके से उसी एरिया में पॉस्को अपना प्लांट लगाना चाहता था. पॉस्को वाज अबाउट टू इन्वेस्ट 52,000 करोड़ इन दैट एरिया. उसने 2700 एकर्स, मतलब 5200 एकर्स उसको लेनी थी जमीन अपना पॉस्को प्लांट लगाने के लिए, और जो है उसने 2700 एकर्स उसने एक्वायर कर ली थी. पूरे के पूरे जंगल काट दिए उसने. 2700 एकर्स, आप जस्ट इमेजिन, किसी भी एक शहर के बराबर होगा. उसने 2700 एकर्स में पूरी की पूरी जमीन, वो जंगल काट दिए. एंड देन गवर्नमेंट ऑफ इंडिया एज वेल एज सुप्रीम कोर्ट, they said no, you will not put up your plant here. After investing so much of money, this POSCO was South Korean company. It had to go back. We have to see कि what kind of development do we want. ऐसे ही वेदांता में हुआ था. उसने उसके 1000 एम्प्लॉइज उसने रख भी लिए थे, प्लांट भी लगा लिया था. बॉक्साइट जो है, जो हम लोग इंपोर्ट करते हैं, वी वुड हैव बीन एक्सपोर्टिंग, लेकिन उन्होंने, वहां के इंडिजिनियस पीपल ने कहा नियमगिरी इज आवर गॉड, if you dig it up we will die, है ना, तो we will not let you dig it up. Of course their feelings were, अब वो जो है 2004 में वेदांता आया, 2010 तक उसने वहां पे काम किया, and then Supreme Court came up with this thing directives कि भी नहीं, ये यहाँ पे जो है ये नहीं, चूंकि वहां की 52 पंचायत को कॉन्फिडेंस में लिया गया, जो उनका डिसीजन होगा वो माना जाएगा. उन पंचायत ने मना कर दिया कि भाई हम जो है नहीं चाहते यहाँ पे, वो he had to go back. अब आप लीजिए एग्जाम्पल सरदार सरोवर डैम का.
The chair, if you would want to intervene.
Yes. Yeah, the answers have to be very short and crisp, to the point, sir, because we are paucity of time, you know. So.
मुझे एक्सप्लेन करने की ज्यादा आदत पड़ गई है मैम, तो वो मैं उस एंगल से बोल रहा था, है ना. वो स्टूडेंट और टीचर का फर्क आप समझने की कोशिश करिए. तो जो है मैम क्या है कि कोविड में the medical facilities were not available. This virus reached everywhere. The migrant people from Delhi or the other metropolitan cities, they came back to their homes, है ना. और ये virus, it is a contagious virus, so it reached those people, but we do not have that actual data कि इसकी वजह से कितनी deaths वहां पे हुई, the oxygen की problem कितनी वहां पे हुई. Of course, if the metropolitan cities were facing so कह लीजिए huge problem of oxygen, they might have also faced. अभी उस लेवल पे आप जो जिस एरिया में रहता है, बिहार में आप सड़कें देख लीजिए, आपके शहरों की सड़कें ठीक नहीं होंगी, तो हम जो खामार ट्राइब मैंने आपको बताया, जिसके सिर्फ 666 लोग रह गए हैं, उन तक पहुंचने के लिए क्या फैसिलिटी होगी. है जैसे आजकल बाढ़ का सीजन चल रहा है, आपका खुद का शहर जब डूब जाता है, तो गवर्नमेंट से हम क्या उम्मीद करें कि भी जो है उन लोगों के लिए कुछ कर रही होगी. नो स्पेशल फैसिलिटी वाज गिवन टू दिस इंडिजिनियस ट्राइब्स, दे डिड नॉट गेट. लेकिन एक बात हमें ये भी माननी पड़ेगी, दे हैव, जैसे मैंने आपको शुरुआत में अमेरिका, अफ्रीका के एग्जांपल दे करके बताया था, इनकी अपनी पर्सनल इम्यूनिटी इतनी सॉलिड होती है, दे कैन फाइट अप विद द डिजीजेस, बट दे कैनॉट फाइट अप विद द इंक्रोजन ऑन देयर लैंड्स और इन देयर कल्चर। वहां से ये जो है इंडिजिनियस पीपल जो है खत्म होने शुरू होते हैं। सो द स्टेटस, अब आप अगर इकोनॉमिक वगैरह उसमें आप जानना चाहेंगे तो गवर्नमेंट ऑफ इंडिया का कहना है कि देयर इकोनॉमिक कंडीशन इज वेरी पैथेटिक। गवर्नमेंट रिपोर्ट आपको मैं कोट कर रहा हूं एक सेंटेंस के अंदर। ऑन सोशियो इकोनॉमिक फ्रंट, एज पर गवर्नमेंट ऑफ इंडिया रिपोर्ट, व्हाइल द ओवरऑल पॉवर्टी रेट्स अमंग द ट्राइबल पॉपुलेशन हैव फॉलन कंपेयर टू प्रीवियस ईयर्स, they remain relatively poorer and weighed against other social groups. ये मैं 2015 की आपको रिपोर्ट बता रहा हूँ, उसके बाद की of course I could not get. Anything else?
Thank you for that, sir. Thank you so much. Yeah, Dr. Prabha.
Thank you, Dr. Preeta. My question is directed to Mr. Valan from the National University of Law in Tamil Nadu. So
Mr. Valan, are you here? Mr. Valan?
Yes, ma'am.
Yeah. So my question, first of all, I want to make one observation is that your topic was different, and in that way it was quite interesting. But I thought that any good research paper should be limited to time and space. You more or less dealt with the whole of India, and then you had a sort of comparison with whether our laws were, could be compared to the international standards. And at the same time, you were showing police brutality in some of the European countries. And is it not a little bit contradictory?
And one more question, like I'll just want to add, the question raised by Prabha, because I just wanted to ask you, and what about the police rights who had been working 24/7? In limited amenities. So you did not highlight this aspect because we have to take holistic approach. So
and I will also add to that because they're all connected, So every country has its own details about internal security laws.
Yeah.
So, police brutality and what the police does comes under internal security. So can you really do that kind of a comparison? What you did, so you can take everything together and explain it, Mr. Valan.
Sure, ma'am. Thanks for all the questions. First of all, starting with the questions from Ranjana Mishra, ma'am, that is, how about the side of policemen? Of course, there are a lot of plights from what the policemen has undergone on that area, on their end. And that's why actually due to paucity of time I couldn't explain it further, but I essentially highlighted the fifth recommendation, that is the cooperation from the citizens also on this end, so that it will make accountable of all the stakeholders in protecting the rule of law. In that way, I've essentially highlighted in my paper that towards the conclusion, I've said the pandemic emergency has significantly impacted the police community and also the public trust in police. And one of the most difficulty aspects of pandemic policing is sustaining relationship with community while adhering to the new regulations and restrictions. And these are not just sweeping statements, but I've added value to it by citing a lot of sources. And also I've asserted that the extensive research on implementation strategy during emergencies in general and pandemic in particular reveals that the style of policing often depended upon the citizens' response towards the emergency. As ma'am has rightly emphasized that 24/7 the police have toiled to enforce the lockdowns, and also they had this kind of frustration, psychological aspect that influenced the police brutality and high-handedness. So that's why I've also essentially highlighted that significant strategy to assist police officers during pandemic is the social support and supportive work culture in general. And I hope that answered your question, ma'am. And also towards addressing Dr. Prabha, ma'am, that how is it possible for highlighting whole of an India, and also how is it reasonable to compare the international law and the relation with the domestic sphere, having the background that even a lot of international countries have violated it. Ma'am, hope I've got your question rightly.
Hey, sorry, what I wanted to say was that you are saying whether we are comparable to the international standards of lockdown. That is the title that you suggested. But then you are showing the brutalities of foreign countries also at the same time. My question is it not contradictory?
Okay, I understood, ma'am. Ma'am, the police brutality in other countries are not the centric point of my discussion. The fact that it in that way that it was conveyed to you is due to the paucity of time, and I have concentrated a lot on the introductory part, because the lot of analysis part I have skipped, and what the mention about the police brutality in other countries is just a 7 to 8 line paragraph in my paper. So in that way, I think it has wrongly conveyed that I have focused on the other countries also. So I have purely concentrated on the first I have analyzed whether the Indian laws are in consonance with international law, and I straight away came for the domestic sphere and analyzed a lot of aspects, how systematic we are in addressing the police brutality in the pandemic. So that's hope that satisfies your question, ma'am.
Yeah, that is fine. But then
Prabha, you are on mute. Prabha.
My only suggestion is that just for your future career is you should always limit your research topic to time and space. Take up South India or either North India, so that you can present a better paper. That's what
Sure.
I feel.
Sure, ma'am. Thank you so much. I take that into consideration. And ma'am, on respect to the Preeta ma'am's question, that is, how about the internal security, legal aspects of the internal security of the police? Ma'am, could you please elaborate that question so that I can answer it more specifically?
Yeah, actually, probably what is happening is your title is misleading us. Okay, so once you revisit your title, then these questions probably, you'll be able to sort out well. So my question was whether there is a, say, religious riot or a caste riot in any part of the country within India. Okay, internal security gives us power, or gives the police power to take certain actions. Probably they go into the category of brutality. Okay, so such similar things exist outside of India as well. Okay, that is why we see whenever we put on the news, what do we actually go ahead and see? Okay, that in so and so place they were protesting against lockdown, so and so place there was protest against mask wearing compulsions, and therefore the police are also giving back. So therefore, can you really, that brings me to Prabha ma'am's question, is it really correct to take such a broad canvas and do this kind of a comparison of internal and international security considerations? So
yes, yes.
Probably the canvas should be smaller. Take a small, look at your hometown and look at what happened there, and see that your title communicates exactly what you're talking and doesn't go beyond what you wish to say in the paper. That will really bring about a tightness in what you're doing. Just a suggestion, because since you're a student, and probably that will be the right way to address future papers. You don't need to answer it, just a comment.
Yes, ma'am, I completely understand your concern, and thank you so much for your suggestions also. And I completely now understand that how my research title is kind of very broad, and what I have addressed in my paper is it's a more of in a domestic sphere, and concentrating on either just in India with special reference to police brutality, or concentrating on specific aspect of South India would have been more appropriate, and I have done that. But I think I haven't made proper attempts to check whether the title.
Thank you. I guess any other further questions? Okay. Yes, Ranjana ma'am.
Okay. My question is to Lino Josh. Is he here? Lino Josh? One who spoke on mental health?
No, ma'am. I don't see him.
Okay. Then my question is to Manju and Kusumika Singh. Are they there? Manju and Kusumika. I can see they are there.
Yes, ma'am.
Yes, ma'am.
Okay. At the outset, I really want to congratulate both of you because it was a very good attempt. But my one query was, you started with 1951 convention. And what about Indian Foreign Act 1946, which considers, refugees as illegal migrant? So you did not touch upon that topic. So can you just tell me, because this thing, laws, starts with 1946.
Ma'am, yes, ma'am. Due to the paucity of time, I was not able to touch upon it at all. So yes, ma'am. So there is Foreigners Act 1946, which deals with any person who comes outside India to India. However, the problem with the act is that it's inadequate to deal with specific needs of refugees because there is no type of distinction made between asylum seekers, illegal migrants, or refugees, leading to the omission of refugee status to vast majority of claims. So the Foreigners Act mainly focuses on foreigners in violation of laws and not in specific to refugees. So it fails at management of people as it doesn't differentiate between the purpose of visitation or entering into India. So despite like a wide range of people from tourists to fugitives or to migrants or to refugees who enter the state, the act uniformly treats them as intractable and an undifferentiated regime. So it makes them refugees to govern these rights or get these rights under the compassion or generosity of the Supreme Court of the courts, and not, it doesn't work as a right-based approach. It just works as they are treated just merely based on compassion and generosity, ma'am. So that is there.
Thank you. Manju, may I make one suggestion to you and your
Yes, ma'am. Yes, ma'am. Sure, ma'am.
So again, it's just like what we told Mr. Vallan, very huge canvas. When you know that you have a 15-minute presentation, what I would do is a very small study where I will cover all aspects rather than touch and go. And like, why would I compare Greece, which is, at the juncture of Asia, Africa, and Europe? Why would I compare Greece with Belgium, with the US, with India for a 15-minute presentation? So just a suggestion that in future, take a very small area, and in your conclusion, probably you can, touch on. But otherwise, what happened was Greece took almost 10 minutes. Yes, Belgium was 2 minutes. Yes, USA, you just said USA and it was over. And then it came to India. So, we didn't get anything. Yes, whereas the paper was quite rich. And had you, taken a small thing for one paper, probably it would have been more justice done, because you seem to have done a very exhaustive work, but the communication did not happen.
Yes,
ma'am. She could have emphasized on Rohingyas, just
yes. Yes, it was there on my presentation, ma'am, but due to paucity of time, was not able to.
Ma'am suggested you.
So yes, ma'am. Sure, ma'am. Thank you, ma'am. Thank you for the suggestions.
Thanks.
So, yeah, next time we'll actually look into the time management thing. Yeah.
Thank you. I think we proceed further, and I request Professor Preeta Nilesh to kindly give the concluding remarks.
Thank you very much.
Ma'am, I'm sorry to interrupt, ma'am. This is Valin. Sorry, I got disconnected due to some network issue when I was speaking to Dr. Preeta, ma'am. Ma'am, I essentially I was thanking you for giving me such a good suggestion, that, and also Dr. Prabha Ravi, ma'am, and Ranjana Mishra, ma'am, for enlightening me about concentrating on whether the title reflects the the spirit and letter of the whole research paper, and though and I've also conceived that as working on a specific aspect of an issue and concentrating on various perspective and aspect of that particular issue would be a more appropriate. And of course I did that, but due to paucity of time, I couldn't convey, and that time constraint also, I'll take that for consideration in my future presentation. And thank you everybody for your inputs.
Yes, thank you, Vala. We please continue. Sorry, Dr. Preeta.
No,
you may
no.
please continue.
Not at all. I just, in my questions, I think I have said a lot what I wanted to say, but I really thank the conveners of this conference for taking such a very, such an important topic for this webinar today. Also, congratulations to all paper presenters for the inputs that they gave us. Since everybody seems to be young here, the paper presenters especially, please keep in mind the suggestions that we have given for any future presentation. Take a smaller canvas, do a very, very in-depth study rather than touch and go, because then you will be able to field questions also in a better manner. And also ensure that what you are saying relates to the main topic of the webinar. So the topic of the webinar was the second wave of COVID-19. And that somewhere, you know, there was a little gap in the paper presentations that were done. But nevertheless, congratulations for the great efforts. And thank you for letting me be here. And thank you for letting me speak. Thank you, Dr. Vidya Lakshmi, for managing time. It's a very, very difficult task, you know, because everybody likes to hear their own voice. And when you have to tell people, okay, it's time up, it's a rather unpleasant task. Thank you very much for saving me from doing that very often. And it was great meeting with old friends. Thank you very much.
My sincere apologies again to the chair and all the panelists. We've exceeded our time schedule, and I can't thank you much more, ma'am. I'm sure I'm going to see you at the campus when we are back to our regular normal and not the new normal. It has been indeed an intellectually stimulating treat, and especially for the young researchers. Such a learning experience will surely pave our path for the near future. Thank you. And we end with our technical session 8. We meet for the valedictory session, which is scheduled today at 2:45 p.m. It is the same joining link. We see you again at 2:45. Thank you, ma'am. Thank you, Preeta, ma'am, for your valuable time and insights. It was a pleasure to hear from you. Thank you, Prabha, ma'am. See you at 2:45.
Thank you. Bye.
Bye-bye. आप YouTube connection बंद कर सकते हैं, madam, and we meet at 2:45. Meeting 2:45 को शुरू होगी. Thank you, Ranjana ma'am. Thank you, Prabha ma'am. We'll see you then. All the attendees, please request all your colleagues and paper presenters to join in at 2:45 p.m. sharp. The feedback link and certificates will be given during the valedictory session. Thank you.